Okay, everybody. So I think we're ready to get started. My name is David Oliver. Thank you all for attending this provider of last workshop. This is the second one in the rulemaking for this proceeding. I'm going to go over a few, excuse me, I'm going to go over a few details first, and then we're going to start with some opening comments from Commissioner Houck. So if we just start here with some preliminary information, we're going to have, during each of these panels, we're going to have a question and answer protocol or question and answer session at the end of each section. The participants will be able to, the panelists who will be there will be able to unmute themselves, but the attendees should raise their hand or put something in the Q&A just to keep it a little bit more orderly. And if you introduce yourself and who you represent when you do that, that would be very helpful. This is a Q&A, of course, or a comment section, time for that. And besides that, notice that this is being recorded and will be posted online for subsequent viewing. So just to let you know that beforehand. I assume that's everything for now. So I'm going to go over the agenda real quick. As I said, we're going to have opening remarks with Commissioner Houck. And then we're going to start with the Energy Division here. Dina and myself will be presenting a proposed POLR framework kind of going forward as we start to really understand this issue more over time. We'll have CCA, and it says SDG&E here, but SDG&E will not actually be presenting a definition of POLR service. I apologize for that. But CCA will be discussing definition of POLR service in coordination that they've had with the IOUs. So there's been some discussion between those parties. There'll be a short break, and then we will talk for the rest of the morning on resource availability. We have several parties discussing that. And then after that will be lunch, then liquidity needs, Pacific Gas and Electric and CCA. Financial monitoring of the CCAs will be next, and then final remarks from Commissioner Houck. Just a reminder that there will be a chance to provide comments, written comments after this, as outlined in the ruling that was presented or sent to the service list earlier. And with that, I'm going to hand it over to Commissioner Houck for some opening remarks. Commissioner, the stage is yours.
Thank you, David. And I just want to welcome everyone to the second workshop in rulemaking R.21-03-011 to implement Senate Bill 520 and specifically to establish rules and requirements for how we can implement a provider of last resort framework that will continue to provide safe and reliable service for electric customers. As reflected in the discussion during our October workshop and in the opening comments filed last December, there's a number of complex issues to be considered in this proceeding, ranging from POLR liquidity and resource availability needs to avoiding unnecessary cost and minimizing rate impacts for both bundled and unbundled customers. So finding thoughtful solutions to these complex issues is going to require collaboration amongst the different interests and parties to this proceeding. As reaching common ground is going to provide a strong foundation for moving forward with these complicated matters. Over the course of the past several weeks, I've met with a number of the parties to the proceeding to better understand the concerns and perspectives among the different load serving entities and the LSEs and ratepayer advocates. At the same time, I understand that the LSEs have been in regular communication with each other, leading to a number of joint proposals between the IOUs and CCAs that will be presented today. I want to thank all of the parties for their continued efforts to find collaborative solutions addressing the core issues in this proceeding and look forward to hearing more on the status of these discussions during today's workshop, as well as reviewing all the written party comments that are going to follow the workshop. I'd like to acknowledge and thank David Oliver and Dina for all of their great support and continued work on this proceeding and preparing for this workshop. I also want to recognize and thank the newly assigned administrative law judge, Jessica Heck, who's hit the ground running in the proceeding. And together with Energy Division staff in my office, I also want to provide special thanks to Aaron Siebert, the advisor in my office, who's been working on this with staff and the administrative law judge. So with that, I want to thank you, and I'd like to turn it over to Administrative Law Judge Jessica Heck, if she's here, to briefly introduce herself before turning it back over to David for the to moderate today's workshop. I don't know if Jessica's here.
I don't see her here at the moment, so.
Okay, then I'll turn it back over to you, David, and thank you.
Okay. So thank you, everybody. I'm going to turn it over to Dina Mackin at this time, as she is going to be leading the discussions on this. Dina?
Great. Hi, everybody. Thanks for joining us for this discussion today. Can you forward the slide to the next slide, please?
Absolutely.
Next slide. So I want to go over once again the key requirements of SB520 as they are framing our objectives for this phase one of the workshop. The key requirements of SB520 are that the IOU shall be the provider of last resort unless the CPUC designates another load serving entity to provide service. And as we've discussed before, the provisions regarding the designation of an alternate POLR will be addressed in phase two. The POLR shall receive reasonable cost recovery for being designated as being provided as providing services the POLR, and to ensure the achievement of the California clean energy goals, the CPUC shall establish rules for all LSEs in preparation for a large unplanned customer migration, and recommend modifications to regulations. The IOU shall provide billing and collection services for the POLR, and the CPUC shall supervise and regulate the POLR to ensure customers are provided electric service without disruption. That is the basis for what we are framing for this proceeding. Would you go to the next slide? Background, as we discussed previously, the scoping memo identified three phases. Phase one will be current gaps in the POLR process for the IOU. Will identify the current gaps in the POLR process for IOUs. And phase two will determine how a third party could be allowed to act as the POLR and consider any other issues that may need to be addressed. So the first workshop we held on October 29th, in that we examined the gaps in the current process. Subsequently, parties submitted proposals in response to the first workshop. And this workshop is identifying the proposals for new policy areas that would address these gaps so that we can further discuss them. Next slide. So to clarify the problem that we are trying to achieve, to address in phase one of this proceeding, and extend beyond the current framework for the IOUs serving load when there's an involuntary customer return. The CPUC has adopted and implemented a process to return to the customers to the IOU in the event of a failure. And under the conditions in which IOUs have resources to readily absorb customers, this process currently serves its purpose. There may need to be
Dina, it appears you've been muted somehow.
Sorry, what was the last thing I was saying when I got muted? Well, I'll just say, however, if the LSE fails and the POLR is not readily able to secure the resources needed to serve the returning customers, not only will the procurement costs spike for returning customers, but the capacity shortfall would continue impacting the cost for everyone. In a worst case scenario, the conditions could lead to additional LSE failures. The POLR must be able to perform its responsibilities even in the event of a large and/or cascading failures and in extreme market conditions when the resources are not readily available. So the additional components of this framework are to develop an emergency plan to ensure the continuity of service in such conditions, and consider actions to minimize the risk of a catastrophic failure occurring in the first place. So with that, we have proposed the following framework. Next slide, David. And so the framework is to have that there's two major areas of phase one of this proceeding. And the first part is to consider these conditions in which we might need to expand the role of the POLR in order to ensure continuity of service under the case of a major market event. This would be an emergency plan. This would apply to CCAs and ESPs. And then the other component of it would be LSE monitoring and risk management, so that we identify at-risk CCAs and examine the financial issues ahead of time to minimize the risk of its impact to the rest of the energy market. And so this workshop today will be examining this component of the framework. We also will be continuing to discuss and putting out a proposal and putting out a ruling to consider and review the existing requirements for returning customers to the IOU as part of a POLR process. And those include the cost recovery, which is mostly focused on the financial security requirements and reentry fees. And we will review any revisions that are necessary to reflect the accurate cost recovery, as well as formalizing the deregistration process and compliance requirements for customer return. We've had some experience with this in practice, but it has never actually been codified in a commission decision to provide direction. And so, as I said, we will be further examining those parts of the framework in a future ruling. Next slide. Okay, so so as I said, this would be our phase one work plan. And I don't know if there's anything additional to say about it at this point. And so next slide. So this workshop is built around looking at these issues. We'll be discussing in this workshop today the access to liquidity, which was an issue that the IOUs raised in their comments to the previous workshop. That if the IOUs are required to procure additional resources on short notice, there may be issues related to having and needing additional liquidity to perform their activities. This would be particularly relevant if the IOU itself has credit problems due to the extreme market conditions. The second issue we'll be looking at would be emergency procurement or access to generation resources. LSEs that declare bankruptcy may default on contracts, and resources may be resold to the POLR for much higher prices or be sold outside the CAISO territory. And so we'll be examining how we are able to make resources available. And finally, we'll be examining just the definition broadly of what the POLR service needs to accomplish, particularly in extreme conditions. Next slide. The second part of this will be examining the risk management and financial monitoring. While public financial information is available from CCAs, it is disorganized, decentralized, and buried in layers of documentation. And so we will be examining what financial information is publicly available, and what we do need to do to gather it. And should and consider whether hedging positions should also be reported. Next slide. So further our discussion this morning, we want to get feedback from parties on whether this proposed framework actually accurately captures the core problem statement, or if there's any other issues that need to be considered as part of this phase 1 framework.
Okay, so we're ready to take questions. Everybody just remember to use the raise hand feature. It's located in the bottom of the screen. There should be a little hand, and you just click on that. That's the raise hand feature. I believe we have a question from Evelyn Call. Andy, why won't it let me? Oh, okay, you're unmuted, Evelyn. You might be muted on your side, maybe. I'm not hearing anything.
Can you hear me now?
Yes.
Okay, sorry. Third try is a charm. All right. Could we flip back to slide 9 or 10, please? It's the one with the boxes.
Evelyn, could you say your affiliation, please?
Oh, I'm sorry. Evelyn Call for Cal CCA. Is it? Yeah. I think it's 9 or 10. Yeah, it's that one. Thank you very much. So I see that the second set of boxes over LSE monitoring and risk management, the prevention strategy applies only to CCAs. And I wanted to explore with you why it is that it's only CCAs that are considered, because it sounds to me in the way Dina described the issues and what we're trying to address today that we're really talking about the tail risk, a disaster, right, in the market where bad things happen with prices and supply availability. And I think I've heard you refer to Texas before. So in the case where you're at a tail risk situation, wouldn't all LSEs be vulnerable, including ESPs and IOUs?
I would agree, yes. All LSEs would be at risk. I think that this has been a matter of a practical consideration of what is publicly available. And I think that the risk to residential customers is specifically acute because of their limited options and awareness of their position in the market, that they may not have actively selected their service, and so it seemed like an area that was the rules around ESPs reporting and confidentiality requirements are somewhat different. And so it didn't seem like this was something that would be feasible with ESPs, but we're definitely certainly open to input and feedback on this.
And I would just add that there is one of the differences, obviously, between CCAs and LSEs is the opt-in versus the opt-out possibility. So not that that's a determining factor, but there is some difference in terms of the customer side for each of these LSEs. So Jean Armstrong, I apologize if I did that wrong, but you have your hand raised, you can speak now.
Yeah, Jean Armstrong with the Solar Energy Industries Association. So I have a question also, I guess, on the same slide that Evie was discussing. With respect to the proposed framework and the continuity of service plan, it seems like you all are saying that this would only apply in a setting of a major market event where, you know, maybe several load serving entities are at risk. But it would seem to me it would also apply, or could also apply, in the situation where just one load serving entity was at risk of, I mean, you know, went bankrupt or deregistered. In that situation, which could be confined to their own, you know, financial issues, their customers would be at risk, and the same sort of, you know, protections that we're putting in place for a major market meltdown, so to speak, could also would be applicable to that individual situation as well. Is that what you all are thinking of, or is this just confined? Would this just be confined to a major disruption in the market where the LSEs are at risk of going under?
You're correct. This would could apply under any circumstance where the IOU is not readily able to absorb the customers. I think the important message here is that we do have a framework in place that has been put to the test before, and that's with Edison absorbing the customers from WCE and BProud. And I think we want the framework of the POLR to meet the size of the problem that is occurring at the moment. And so we want to make sure that we don't have an entire, if there's a very large major action that needs to be taken, it is taken, but at the same time, the current framework should be sufficient under conditions where the IOU is readily available and needs some revisions, but the continuity of service plan is considering conditions in which it's not easy for the IOU to absorb the load of returning customers.
Okay, I'm going to let Dan Douglas, you can make your comment now.
Hi, David. Can I be heard now?
Yes, you can.
Hi, I wanted to respond to the initial comment by Evie Call and the response by Dina to emphasize that the Commission has recognized in several decisions that direct access customers are sophisticated financial entities who are very able to take care of their own interests. And the customer base served by ESPs and served by direct access is distinctly dissimilar from that served by CCAs, because residential customers, with a few very rare grandfathered exemptions, are not direct access customers at all. And that concludes my remarks. Thank you, David.
You're welcome, Dan. I also want to note for people on the phone, Scott Douglas of NRG provided a comment in the chat. Very, very few customers were sent to POLR during the February 2021 Texas incidents due to the ability of customers to actively shop to other providers. The same is true with the ESP-DA structure in California. A customer in a failing ESP could actively switch to another ESP without having to go to POLR. Thus, the prevention, in quotes, strategy is rightfully different with ESPs as outlined by Dina. Evelyn, did you want to make another comment?
Yes, one of the things I was thinking about as Dan was talking and as Dina was talking was, you know, I understand that CCAs and ESPs serve different types of customers, but the tail risk that you're talking about here is one in which there are price spikes caused in the market by shortages. And I think that can happen whether you're an ESP, an IOU, or a CCA, regardless of the customers you're serving.
Evelyn, one of the questions I have for you is, are you thinking about this in terms of the monitoring is there to protect the ESP customers or the rest of the market? And do you see the ESP potential failure as having enough of an impact on the overall market to necessitate like having that forward review?
Yeah, I guess when I think of the tail risk, or I think of a Texas type situation, you know, it wouldn't be just CCAs at risk. It would be ESPs who have a significant portion of the market. And even it could be IOUs. Again, it could be any market player that somehow causes a price spike. So it goes, Dina, to your problem statement. What problem are we trying to solve? And if part of the problem you're trying to solve is the risk of a price spike that occurs when there is a shortage of capacity or energy or whatever product you're talking about, then it seems relevant for all types of LSEs.
Dan, did you want to respond to that?
Yes, I just wanted to say briefly that to me, the relevant question is, who are we trying to protect here? Are we trying to protect CCAs and ESPs, or are we trying to protect the customers that they serve? And my answer to that is the issue here is protecting the customers that are served. And quite simply, residential customers are far more vulnerable than sophisticated commercial industrial customers.
Thank you, Dan. We have a note here from Mike Callahan. I'm sorry, I don't know his association. He says, one example to look at for DA market failure is to examine the energy crisis and what happened with DA providers broadly. Oh, and Mike has just told me he's with MCE. They are CCA, Marin County. Is there anybody? Do we have any other questions? Any other panelists or any of the attendees who wish to comment on this further? Well, those. Thank you for the comments on that. We're actually about 15 minutes ahead of schedule, but that's good because I believe some of the other things may take. We can fit in maybe a little bit more discussion on some of the other items there. So if we are ready to move on from there, let me just advance the slides. We are going to start. We're going to discuss the definition of POLR service. Dina, do you want to introduce this topic and our presenter?
I'm going to turn it over to CalCCA to start with their presentation on their view of the definition of POLR service. So we need to, okay, Eric is elevated.
Yeah, thank you, Dina. I appreciate it. I'm Eric Little from CalCCA. We have been talking with the IOUs on this topic. So SDG&E, PG&E, and SCE have all been in meetings with CalCCA on this. And so this presentation, if we can turn to the next page, please, actually does represent a, I'm sorry, I'm getting ahead of myself. So we've kind of looked at this issue from a narrow question of how should the POLR term be defined, right? What is their process? How do those customers get returned? So if we can move to the next slide, please. Thank you. So this is a consensus view of CalCCA and the IOUs. We've had quite a bit of discussion about this. The bottom line on this is we actually think that the current process works very, very well. We do think that there was maybe some confusion in the beginning where we tried to define POLR and provider of the provider of last resort and the default provider differently. In phase one of this, it really doesn't make sense to define them differently because they really are one and the same entity. In phase two, we may have to reconsider these types of things, but for now, we think that the current process works very well. And that is a process in which for up to 6 months, the POLR is serving those customers. They have access to cover any costs through a financial security mechanism. And I'll note that that is not capitalized, the current term FSR, as we all know it, because this process is debating whether it is that or whether it is something new that would cover that. That 6-month period then is also designed to allow time for the IOU to plan to hedge the risk of those customers that are returning after that 6-month period. In discussion with the IOUs, I think we're all in agreement that this process works. It affords the opportunity for the IOU to integrate into their bundled procurement plan. It affords the opportunity for the customers to be protected by the postings that were placed there. And it allows time for everything to be adjusted. I do note the up to 6 months is because we do have examples where it has been 6 months, and we have an example where it was less than 6 months, where the notification of the returning of those customers was given before the load migration actually occurred. And in that type of situation, then the POLR service was not 6 months because the customers didn't return for some period of time into that deregistration process. So that's why it's listed as up to 6 months. If we can move to the next slide, please. This slide is really here to primarily talk about kind of the back end of this process, which is the opportunity for the IOU to be able to ensure that they know what customer load that they're going to have. And we have placed up here, these are the current processes for direct access for large customers, for direct access for residential and small commercial customers, and then for the CCAs. And I'll just go over the CCA line in this one. The option in there for the 60-day safe harbor to find a DA provider, I will just note that is a very unlikely element in that case. It would have to be a customer who is eligible for direct access service. And you can imagine if the CCA has been around for some time and serving that customer load for some time, it's unlikely that there are customers that are eligible for DA service at that point in time. But if there is, they have that opportunity. If during then the 6-month period that the up to 6-month period that we referenced, if they, sorry, reading too fast. If they don't exercise that opportunity in that 60-day period, then after that, they remain on bundled procurement service for a minimum of 12 months. Again, this is to allow the utility to be able to do procurement for its bundled load, knowing how long it's likely to serve that customer. And then there's also a 6-month advance notice to depart. So you can imagine in that 12-month period, what that means is after 1 month, if they give their 6-month notice, they can't depart for 11 more months. If they don't give any notice during that 12-month period and 1 month after they give a notice, they've got 6 more months before they can depart. Again, all in the notion of giving the utility ample opportunity to understand its bundled procurement needs and to be able to adjust its portfolio. So that's actually it for this presentation. Again, I think the bottom line here is it really isn't very different than what we're doing today in discussion with the utilities. We think it works and we think it can continue to work even in the event of a massive return. So I would ask if there's anybody from any of the IOUs that wants to weigh in on anything. If I have missed anything that we had talked about, would appreciate you raising your hand now and adding that in.
Well, I see no hands from any of the IOUs. So I think at least as far as they're concerned, Eric, you did an outstanding job. We have some questions here. Do you want me to, Dina, how do you want to handle this? Want me to go over them?
It looks like Matt Friedman is, has his hand raised.
Matt Friedman with the Utility Reform Network. And Eric, I'm kind of curious about why the 6-month time frame seems reasonable for the POLR or other providers to line up supplies if there's a real market crisis underway and you have a mass involuntary return. Why do you think that in 6 months the utilities would be able to then line up alternative supplies or hedging under reasonable price terms? And how would utilities get new resources built in 6 months if that was what was needed to serve these customers?
So Matt, I'm going to go to your last question first. The building of new resources within a 6-month period, I tend to agree with you. That's not likely to happen. I think that's where the IRP needs to really be doing a good job of understanding what the planning mechanisms are and what is being developed and what needs to be done for that. And there have been procurement mandates in the past to address those types of issues. So from a building of new resources standpoint, I don't think you can realistically rely upon POLR to be able to do that. If our concern here is that this is a mass failure and a return of customers because of mass failure, if there's a lack of capacity, it's kind of too late. And we'll have a bit of more discussion about this later on in some other material that CalCCA is presenting. As far as the ability to procure from existing resources, I would certainly open it up to the IOUs to answer that question. I think historically a 6-month period is what has been used to be able to do procurement and to be able to layer in the necessary energy hedges that they need, as well as going out and procuring resource adequacy and necessary RPS. In the event of a market disruption, are those prices going to be higher? Yes, they are going to be higher. This is what we experienced during the energy crisis days. I'm not sure that I know about how you effectively do that when prices are high and forwards are high. How do you avoid paying those high prices in that set of circumstances? Matt, I don't know that you can. So I think that there needs to be a process by which people begin layering in their procurement at that point. But again, let me open it up to the 3 IOUs because they're the ones who do that type of procurement and they may have a better answer.
While we wait for maybe an IOU, hopefully to chime in. Gene Armstrong?
Yes, I have a couple questions. One with the CCA turnback, and you recognize with the rare exception of maybe a commercial customer going DA, they will, I mean, I'm not sure what the 6 months is for. There's no place else for the customer to go besides the IOU. So it seems like if there's a significant turnback of CCA customers, they will have to be incorporated into the IOU's procurement plan. I mean, there's no place else for them to go. So why the 6 months for them, I guess, is my question. First question.
So the 6 months for a customer to depart afterwards, my recollection is that is presently within the tariffs of the 3 utilities, but I do see a raised hand. It looks like from Janet, who probably could answer this better.
And you can unmute yourself.
Good morning. Jean, I think what we were thinking about is the period of time over which the POLR has a right to recover incremental costs from the load survey entity that failed and caused the mass involuntary return. And the commission has said repeatedly that they think 6 months is an appropriate time frame. And I realize that the question has been raised by Matt as to whether it should be longer, and that's certainly been looked at several times. But so that's our thinking. It's not that they have an opportunity to go back out, to another service provider after 6 months. You know that the current rules don't provide for that. But it's really that 6 month period of time over which the POLR is has an incremental cost exposure, if you will. That's how I'm thinking about it.
Okay.
Janet, can you give your affiliation, please?
SVE, Southern California Edison.
Janet, that was helpful. Is there any other aspect of the procurement itself I was going to ask about? Specifically, what is the planning horizon that you're procuring that is defined by 6 months? What's happening? What is it about 6 months that is a procurement horizon that is defining the period that the IOUs need to procure for?
So I'm sorry, can I jump in here and ask a follow-up question to that before Janet answers? I'm getting confused over which 6-month period we're talking about, because there's really two of them here, right? There's the initial return and those customers then serving under POLR for an up to 6-month period. And then there was that last slide that I had that had a requirement for an entity to notify the utility 6 months before moving on to another service provider. Which 6-month period in this context are we talking about? Is it the ability to move again, or is it upon the return and the 6 months before they become a bundled load customer where they're covered under POLR?
I believe we're talking about the return itself, but I think it does raise the question of, it seems like there's a principle here that's defining 6 months as the horizon upon which the IOU needs to move forward procurement. It looks like Erica has her hand up.
Thanks, Dina. So just my understanding of Matt's question is why 6 months, and does that protect the bundled customers when those returning customers enter into the bundled portfolio? Or is 6 months the right amount of time to make sure that they're indifferent to the returning customers? And I'll say there wasn't a ton of science on our end that went into exactly pinpointing 6 months. I think in our view, that's sufficient, hopefully sufficient time for us to be able to layer in hedges, conduct solicitations, and start to expand our portfolio as necessary. I think there's some things that will help make it easier. For example, the VAMO process for RPS resources might be able to be leveraged to make it easier for us to meet our RPS obligations. Matt, to your question about bringing online new resources, it's insufficient time to bring on new resources, and we recognize that. I think if we were to design POLR to bring on new resources right now, POLR would be a long period of time. And I think we also have some concerns about those returning customers and keeping them on POLR for an extended period of time. So we're trying to balance those two objectives there.
Erica, can I get your affiliation, please? Thank you.
Oh, sorry, PG&E.
Evelyn, you raised your hand. Would you like to?
Yeah, and thanks. Evelyn Call from Cal CCA. And the only point I was going to make is the questions we're getting into now are like IRP, do you have enough RA, do you have enough RPS? And that's in the next session, I believe, where we go more deeply into how you resource those types of products.
Okay. So, Jean, did you want to respond to that?
No, I actually had a follow-up question.
Absolutely.
To what Janet said from Edison about the 6 month period sort of represents the time period when the IOU can recover their incremental costs from the CCA. What's included in that incremental cost? Is that, well, I'll just ask it. What's included in those incremental costs? Is that also procurement cost, or what is that?
Janet?
Hi, Jean. This is Janet Combs from SCE. It is called a reentry fee, and as you know, we recover, the reentry fees. Well, on transitional bundled service, which is what some customers go on over a 6-month period of time, and up to 8 months if they're DA because of that safe harbor. It's procurement costs and admin costs. The same thing, it racks up the same way if you have a mass involuntary return and they're skipping TBS and going into BPS. It's that reentry fee calculation that racks up the same way: energy, RA, RPS, and then an admin component. So yes, it includes procurement costs and an admin component, whether you're on TBS or you're calculating it and trying to recover it in a mass involuntary return.
Okay, thank you.
Are there any other questions at this time on this topic? Carl, okay. Carl,
It looks like we have Carl.
Carl, can you please tell us your affiliation and your time? You can unmute yourself.
Thanks. Yeah, Carl Stoller with Cal Advocates. Yeah, I just had a point of clarification on the problem statement. The last item said, consider actions to minimize the risk of a catastrophic failure occurring in the first place. Just wondering how catastrophic failure is defined there. Is that just failure of a CCA, for example, or is it a failure of the market? Or
I think in this case, we're thinking about it in terms of a CCA's failure having impacts on the market that could lead to financial instability for other entities. There was concern when WCE failed that the unpaid accounts for its scheduling coordinator could put the scheduling coordinator at risk. And if that was the case, it could have impacts. In that way, it would lead to cascading financial issues throughout the market because so many entities are have financial relationships with so many other entities that if one is not able to provide its service, it can put other ones at risk.
okay, thank you.
And so I think by having forward information about a LSC that is in financial trouble could help alert. First of all, it can help the IOUs plan for the return of the customers, the CPUC to plan for a return. Provide early enough warning to these other entities so that they can either shore up their financial resources, they could, make decisions with enough time that they are not short on cash flow before, and end up without cash flow.
We're now discussing the resource availability section, and we have several presenters here. There's Mr. Walsh from SCE. He will be our first presenter today. Take it away, Bill.
Thank you. So I'm Bill Walsh. I'm the Vice President of Energy Procurement and Management here at Southern California Edison. I'll be going over the consensus positions of the IOUs and Cal CCA for what do we do with RA, IRP, and RPS obligations when CCA customers return back to the POLR service. So thank you for having me here, and I'll just get us kicked off. Maybe move to the next slide. Thank you. So start off with the RPS. Pretty straightforward. The idea would be that prior to the cessation of service, that the original LSE would be responsible for the RPS obligations before the actual energy needs are being transferred over to and the IOU starts scheduling that load into the CAISO. At that point, the RPS obligation would then shift over to the POLR at that point. I think that's pretty clear in terms of when obligations begin and end. The other point that we would make here is that under certain circumstances, we may need waivers or grace periods for compliance, especially if we're especially large size of return of load during near the end of a compliance period, or just maybe on an off cycle of the RPS procurement plan that doesn't move quite as quickly, that we may need a reasonable amount of time to make up those megawatts. So they're seen as a need to account for that situation where there's a large unexpected return that can't be planned for. With that, I'll move on to the next slide. So this is resource adequacy. So right now, the way it works is it's already contemplated amongst the RA rules that if the POLR can seek a system RA waiver if there's an unanticipated large return of customers back to the POLR. In terms of when the obligation actually switches, that would be at deregistration, and then once Energy Division adjusts the RA requirements along with the CAM allocations to shift it over from one entity to the next, is when the IOU would pick up that obligation. Given the T45 structure of the RA compliance filing, usually that will naturally be pushed out into the future, just the way the RA compliance filings work. But once that official switch is made by Energy Division, after the deregistration is when we would propose that the obligation actually switches over to the POLR in this instance. So in terms of consensus proposed changes, all the entities do not support advanced procurement or hedging for this mass involuntary return for a whole host of reasons, including increase in costs, unclear what you would be procuring to, could strand valuable assets, a whole series of things. Very difficult to administer, and especially in a tight RA market, could actually have detrimental effects. I will say one sort of minor caveat to that: if there is a written advance notice that a known involuntary return is going to occur, in that case, the POLR, if it's out far enough, could start to plan for those obligations. But again, I would say the waiver would always be out there in the event that it would be difficult to procure these resources. Obviously, the summer times would be much more difficult versus the non-summer months in terms of making these obligations moving forward. With that, I'll go to the final slide that I have. This would be IRP. So for the IRP obligations, right now, there's no clear framework on how that transition occurs. In the event of a large migration, I think the decisions refer to an advice letter that's filed, but not a whole lot of direction around how it's done and when it's done and what the rules are around it. Although it looks like we have two different positions here, I would say they're actually pretty close together. If a facility's been constructed or is going to be constructed under a CCA prior to the involuntary return, that would be satisfying the obligations. If it hasn't been constructed or needs to be constructed, then moving forward, once the obligations are switched in deregistration, at that point, the POLR will need to fill it at some point. I think the way we're proposing that works is similar to RPS and RA to some extent, that there needs to be a waiver or grace period in order for that to happen. So our ability to turn around and procure resources, especially like, say, for example, today to meet a 2023 need, would be difficult, and it just gets more difficult as we get closer to 2023. So adjusting for that will be important in understanding that. I think the one caveat on the bottom is referring to near-term procurement. If there's some sort of emergency reliability need, that might be some additional changes that we're going to need to make. But for the most part, a grace period or a waiver would be the most effective method of ensuring in the future that we can keep cost allocation equitable, as well as make sure that we can go out and procure the reliability resources that are needed. So that, I don't know if there was time for questions or we're holding it till the end. I'm free to do whatever you guys want me to do.
Why don't we wait till the end? and get all the questions, have like the panel at the end to answer questions in there. Somebody says they're having a strong echo. Is there anybody else getting that? I don't see a couple people on screen, but if that's the case, that might mean somebody's on, but let me, okay, audio's clean, okay. So the next, we will move on to Eric Little again. He will be presenting on behalf of Cal CCA. Some discussion on this issue as well. Eric, you can unmute yourself at this time.
Yeah, I think we actually, for Cal CCA, this is going to be a joint effort with, we'll need Evie on as well, and
Okay.
then Val on also.
Take care of that. Lee and Val. There's two Valeries on here. Two Valeries.
Bantner Peo.
Right, she's got two on here.
Okay.
Yeah, she should be on now. Valerie, you can unmute yourself.
Thank you.
Thank you.
Okay.
And maybe before we go on to, I had my hand up for Bill's presentation, and obviously we agree with what Bill had to say about our agreement. But I think I just wanted to point out that there seems to be a big concern over whether there will be sufficient capacity, IRP capacity, in the event of, again, a massive failure, a tail kind of failure. And one of the things I wanted to point out is the Commission currently has control over how much capacity is getting built and has exercised that control. We've had the two recent procurement orders directing additional capacity development. And CCAs, I think we've shared in a number of forums the fact that CCAs are ahead of their obligations for IRP procurement mandates for 22 and 23 already, even with some of the delays we've been seeing. So, you know, the question of whether the premise is valid of being highly concerned about whether that capacity is getting built, I think we have to look at that realistically in the context of what's actually going on with the IRP procurement mandates. And if there aren't questions, I can move on to the next slide.
Why don't we move on to, okay, I'm sorry, yeah, let's move on.
Okay, so the issue we've been asked to address is whether there's a way to resource the POLR from contracts that are in the portfolio of the failed CCA or ESP in this case. So if the POLR is obligated to pick up a group of customers, can it simply take the contracts the CCA has and use those contracts to serve the customer? And that has two dimensions to it. One dimension is being able to have the resources available, so the availability of the capacity or RPS. And second is to have it available at a reasonable price, which is if the market has been driven up, being able to capture the value of that contract at its original price. Cal CCA has done a lot of work on this, trying to understand whether there is a way to have some kind of automatic assignment provision so that if there were a default or failure into bankruptcy, that there would be automatic assignment to the POLR. And we've run into a number of issues. There are policy and market concerns, which Eric will talk about, and then there are numerous legal concerns as well. And we've brought our bankruptcy counsel today to talk through those legal issues. Eric?
Yeah, thank you, Evie. So I think that there's at least 4 areas that we've kind of taken a look at where there's some difficulty here. And thank you, David. The first one is in complexity of the supply procurement to begin with. And I recognize that if you place this provision of being able to assign this contract, in most cases, it's going to mitigate risk, right? Because now you've got the probability of 2 parties defaulting, which is typically less than the probability of an individual party defaulting. The problem is, though, is that what if the provider of last resort is actually in dire circumstances to begin with, right? We have seen situations in which a utility has been bankrupt. And so if you're trying to sign a contract for resource adequacy or to meet IRP or to meet RPS, in which you're saying that there is an assignment potential of this contract to an entity that is already in bankruptcy and that bankruptcy proceeding is going to last for some time, it's going to be a difficult contract to be able to sign. So it's going to present some risks there. The second is in complexity of managing your portfolio of resources. So just imagine we don't get into this concern of the market is falling apart and this LSE finds themselves long of a particular product and wishes to sell off that excess position to be able to minimize their customers' costs. In such a situation, what does it mean to have that assignability in a contract that you've now sold to somebody else? In particular, what if that contract has been sold out of state? What does it mean to a purchasing entity outside the state of California to have a contract that says that if there is a default, that contract now is assigned to a provider of last resort inside of California? And I suppose whose default is it that triggers that? The original purchaser or the new purchaser now outside of the state? So there's a lot of things in complexity that would have to be addressed. It has a potential to increase costs. Again, as I mentioned earlier, if there are these risks with this entity that is unrelated to the purchaser and the seller, this third party that's the provider of last resort, that is going to have a tendency to push costs up, and those are going to be paid for by the customers who then are being served by the entity that's trying to sign that contract. And then the final one is really on, is this only applicable to new contracts that are signed after this provision goes into effect, or is there an expectation that folks renegotiate existing contracts? And I know that the Public Utility Commission and the ISO have heard on a number of occasions the difficulty with having to do renegotiations of contracts. These are signed with a whole bunch of different terms and conditions, as well as prices all considered at once, and going in and changing one element is not as easy as it sounds, because all of the other elements were dependent upon everything else that was negotiated in that contract. So I think from a policy standpoint, there's a number of concerns of being able to do this, of how this works out. So I'll stop there and I will hand it over to Val for the discussion on the legal side of things.
And I understand Val may need to be promoted again. I thought she was having some.
I think it's been addressed.
Okay,
Thank you,
terrific. Thank you.
Excellent. Well, good morning, everyone. My name is Valerie Bantner-Peo. I'm an attorney at Buckhalter in San Francisco, and I spend a lot of my time in bankruptcy court, typically representing creditors. And so for that reason, Evie and Eric asked me, excuse me, to join the discussion this morning and share a couple of thoughts about what I perceive to be the bankruptcy issues raised by this proposal. So taking a little bit of a step back, the sort of reason that anyone seeks bankruptcy protection and the sort of goal of the case is to centralize the company's assets, centralize the claims of its creditors, and provide for some kind of orderly disposition of those claims, either reorganizing the company or liquidating it. And one of the key assets of any bankruptcy case is going to be its contracts. And so for that reason, there are a lot of provisions of the bankruptcy code that deal with how contracts in bankruptcy are addressed. So with that overview, I think we can click to the next slide, please. So one of the most powerful rights that a company in bankruptcy has is the ability to either assume or reject what are called executory contracts. Executory in the bankruptcy context just means that the contract is live. There are performance obligations remaining on both sides. Once a contract is deemed executory, that's when this right to either assume or reject is triggered. If the debtor, the company that has filed bankruptcy, decides to assume the agreement, that means it has to be responsible for all of the obligations as a counterparty, and the contract goes forward as though no bankruptcy happened. If the contract is rejected, the company is no longer responsible for it, can shed those obligations. So you can imagine, something that's got a favorable pricing term, other favorable terms and conditions. The company in bankruptcy is going to want to keep those and use them in its reorganization or liquidation effort. If the contract has unfavorable terms or conditions, the company may wish to shed it, and the bankruptcy code provides a mechanism for it to do that. An important provision that protects that right to either assume or reject is a provision of the bankruptcy code that disallows contract provisions that operate automatically. So, for example, a contract provision that says, if you file bankruptcy, you have to pay cash on delivery. Or if I think that your financial circumstances are uncertain, I can change the terms or I can terminate. Broadly speaking, those kinds of provisions aren't enforceable. So I think the notion of an automatic assignment of an LSD's contract to the POLR is going to trigger this general prohibition in bankruptcy on an automatic trigger. I will mention, for the sake of completion, that there is an exception to this rule for forward commodities contracts, which at the election of the counterparty can be terminated in bankruptcy. There's a lot of case law about what qualifies as a forward commodities contract, so I don't want to get too far into that. However, under the bankruptcy code, the idea of assignment and termination are, I was going to say polar opposites, but then I thought polar might not be the right word choice for this discussion this morning. They're sort of mutually exclusive options. A contract that has been terminated is done. It cannot be assigned. The only way a contract is assigned, at least through the bankruptcy process, is if it is first assumed. All of the defaults under the contract must be cured. And then at that point, under the bankruptcy code, of course, subject to exceptions that I don't need to talk about today, the agreement can then be assigned to another counterparty. Another important, I think, caveat to that right is that the contract is assumed and assigned, we say, in toto. So you can't assign the contract in bankruptcy for 3 months or 6 months if the term of the contract goes on for a year. You take the contract as you find it. So I think I've said a fair amount on this executory contract issue. So I did want to take a beat and just see if there were any questions. Excellent. Well, the last thought that I'll share on this issue is the notion of, centralizing assets and claims in a bankruptcy case. And so I think anytime there is a regulation or a contract provision that potentially takes a valuable asset away from the company in bankruptcy, that's something that's going to be scrutinized. It's going to be scrutinized sort of as a matter of the bankruptcy form and proceeding, but also from the perspective of other creditors of that company that want the company to, control as much value as possible so that their claims might have a better chance of being paid. So those are the thoughts that I wanted to share this morning. And with that, I will pass it back to the moderator, unless there are questions, of course.
Well, we'll save questions for after all the panelists have had a chance to.
Excellent.
So now,
David Oliver, you're muted.
Oh, I'm so sorry. I was muted there. Frank, we will let you speak. Frank DeRosa will now speak on behalf of SEIA, LSA, and Solar Production.
Yeah, thanks, David. And thank you all. I'm Frank DeRosa, Vice President for Policy and Government Affairs for 8-Minute Solar Energy, and representing the Solar Energy Industries Association and the Large Scale Solar Association, in which I'm a board member of both. And it's nice to see and hear many familiar faces. And the topic that I'm going to speak to pertains to the Commission's highest priority in this proceeding, and the one most discussed today, and that is to keep the power flowing if an LSE deregisters its customers and stops supplying them. We have a simple answer for that. The supply, i.e. the power contracts, should go with the customer. If an LSE turns back its customers to the POLR steps in and becomes the buyer of the power and uses that power to serve the LSE customers. And I recognize the good points that Eric made about the complexities of that, and I'll speak to that to some extent, and also recognize the issues around the bankruptcy court and say a few things about that as well. But first, I'd like to start with what the benefits are of keeping the contracts with the customers. First and foremost, it assures an uninterrupted supply of power. There are many scenarios that could lead to an LSE turning back its customers, but the one that the Energy Division finds most probable is when there's a capacity shortage and energy prices spike, and the scenario that the presenters have talked about here. Maintaining the contracted supply protects the customers from what could be dramatically higher prices or power outages if there is no supply at all. Second, it assures that there's no cost shifting to bundled customers. The deregistered customers continue to pay for the LSE, for the power that the LSE contracted for on their behalf. Third, the CCAs have proposed that deregistered customers may not need to go to a POLR. That is, that another CCA or a CCA consortium be able to assume the customers of a deregistered CCA. Keeping the contracts with the customers would accommodate that. There'd be no restriction or no reason why that couldn't happen. The fourth benefit is that it provides certainty to lenders and investors of existing and future projects, which translates to lower risk and therefore lower PPA prices. The lenders and investors of power plants with long-term contracts, they value the certainty of a secure revenue stream versus trying to achieve higher rates of return with riskier investments. They're willing to accept a low rate of return for the safer investment. That lower cost of capital, debt and equity, translates, to lower power prices. Keeping the contracts with the customers means that there's a second party that stands behind the contracts in the event of deregistration. And Eric mentioned this. This is a form of financial security. There's a second party standing behind it. Currently, if a CCA on its own is financially unstable, project lenders might require them to post a letter of credit or some other form of credit as financial security to guarantee payment, which could be expensive. especially as the volumes, the loads of the CCA in their megawatts mount. While each case will be different, the added security of a backstop provider will most certainly lower the cost of a CCA's financial security. California's policymakers have recognized the value to customers of honoring long-term contracts, especially in times of financial disruption. Contracts were maintained during the California energy crisis and also most recently in PG&E's bankruptcy. As a result of this stable environment, lenders and investors continue to fund California projects that have long-term contracts, and they're confident that the contracts will stay in place. But if contracts are abrogated, especially in times of broad market disruption, we run the risk that these lenders, these investors who can put their money anywhere in the world would not invest in the next round of power plants in California. So it would really be a high risk bet to allow contracts to be abrogated, leave customers to the volatility of the short-term market, and threaten the flow of low-cost capital. On the point of bankruptcy, yes, I think every party recognizes that the bankruptcy court has the last say on contracts, and we agree. But think about who the creditors would be if a CCA were to go bankrupt. The largest creditors by far would be the power suppliers. If contracts stay in effect, the power suppliers would have no damages, therefore no claims. The Commission can't tell the bankruptcy court what to do, but a policy that assures a steady supply of power for all customers and avoids damages to the major creditor class might be persuasive. And we have history here. Again, the bankruptcies of the utility, which indicates that first of all, in both cases, the bankruptcy court kept the contracts in place, and probably the reason that they did that was because of consideration of the broader environment, the broader policy objectives, and the real need to literally keep the power flowing and keep the lights on. We think that the Commission has broad authority in this area. The Commission has authority, has a responsibility to protect utility operations, protect bundled customers, and also protect customers that have been deregistered. So they have a motivation and a responsibility to make sure that, to the best extent possible, that power keeps flowing, even in these cases. We call them tail cases. We've had many tail cases in the last few years. So it's not. I wouldn't call it a black swan event, that there could be power shortages, there could be price spikes and disruptions. Just one more point, and I'll finish. A ROFR has been suggested as a possible solution for maintaining power supply, but a ROFR is not the way to ensure such a supply. It's a one-way option, an option for the buyer and an obligation for the seller. So existing contracts don't have ROFRs and suppliers don't have any incentive to add one. Requiring ROFRs in future contracts means that means the seller would be agreeing to grant an option to the buyer. That will come at a cost. If it's ordered, that will come at a cost if the seller agrees at all. Parties on all sides of this proceeding, load serving entities such as the CCAs and SoCal Edison, customers such as the small business utility customers, and we suppliers don't believe that a ROFR solves the problem. So thanks. That concludes my comments.
Okay, thank you, Frank. So now we're going to move to Paul Chernick of the Small Business Utility Advocates. Paul, you are up now. You can unmute yourself.
Okay. Can you hear me okay?
Yes, absolutely.
Great. Okay. So, well, that's who we are. And most of my presentation actually covers material that was either assumed or touched on by previous presenters. So I'll try to focus on what's left to add on to the discussion. Next slide. So this whole situation arises if a load serving entity, and in here we're basically talking about the CCAs because there seems to be a general, if not universal, agreement that the larger customers who are direct access can take care of themselves. What happens if an LSE goes out of business? So the LSE starts with an amount of load for which it has matching energy supply, renewable energy, and capacity requirements secured in some way to meet the various requirements. And then it ceases operation and the load returns to the POLR. And the POLR is responsible for providing all of those services. So the question is, what happens to the LSE's resources? Next slide. So if the contracts just disappear, the POLR can purchase resources in the markets, which under some circumstances will be a scramble, either in terms of cost or perhaps even adequacy. If the market prices for those replacements are less than the POLR's average costs, then there's no problem. You can just roll the returning customers into the POLR's supply. But if the market prices are greater than the POLR's average cost, then you've got a problem. Either prices are going to be higher for the returning customers or for all POLR customers, depending upon how the commission decides to handle the issue of integration of returning customers. And unfortunately, those two situations are not completely symmetric because high prices in themselves may increase the chance of a LSE or CCA to fail. Next slide. Now, if the POLR has step-up rights to the contracts, then you can actually do this a couple of ways. The way I've laid it out here, the POLR designates the contracts it wants to take over, and those are simply transferred to the POLR following the customers, as Frank just described in terms of logic and mechanism. And it would be an independent decision for each of the contracts. It'd be written into all future contracts. I certainly didn't expect that existing contracts would be rewritten. I understand that that would be a difficult process. So that mitigates exposure of all the customers to market conditions. And it could actually reduce costs to the POLR customers, depending on the effect of the roll-in and whether the commission decides to do that right away or maintain separate rates for the returning customers for a while. Now, the helpfulness of those measures of this particular approach is limited if the supplier has defaulted, since obviously there's no viable contract to transfer. But it's my understanding that the CCAs generally have multiple contracts, so that it would only be a partial problem, and that the it also is a problem if they're very expensive contracts, although you can resolve that by just saying, well, those customers who were paying those expensive contracts under the CCA now are going to be paying under a special rate from the POLR until the commission designated merger of the rates. In terms of an issue that Frank raised, the right of first refusal generally means if you find a buyer, then the party with right of first refusal can step in and say, I'll take it at that price, which makes it hard to find a buyer, because if you get negotiate a good price, then the person with the right is going to take the contract away from you. And if so that terminology, as usually applied, would not be very helpful in this situation. But and it would probably cause a lot of confusion and put some sand in the gears. Then you have a situation such as the one that I laid out, where the POLR gets to pick and choose which contracts it wants. And that works out very nicely for the transferring customers and or the incumbent customers. It doesn't necessarily work out so well for the suppliers, whom I take it Frank was speaking for. And therefore the commission could also just say, no, all of the contracts that are still active at the time of the transfer of the load move with the customers, and either they're kept in a subrate under the POLR and continue to pay essentially the rates that they paid previously, or the contracts are rolled into the POLR's general rate, again, depending on the commission's approach. And that concludes my presentation.
Great, thank you, Paul. So does anybody who wants to start with comments or questions? Okay, it looks like Jean Armstrong, and actually I want to note that we have had some questions come up during the presentation, but I'll start with Jean Armstrong. Jean, you're on mute.
Yes, I was just given the ability to unmute myself. So I have a question for the CCAs, I guess, Evie or Eric. So if there's a CCA failure, in not every case is the CCA going to go into bankruptcy. They might get ahead of the issue and determine its best interest of their customers to deregister. In that situation, what would happen to the contracts?
From a legal standpoint or from a business standpoint?
Well, either or both.
So I suppose to the extent that the entity has decided to, this sounds like a voluntary return of customers to me. They're going to presumably provide ample notice for that voluntary return. And then if they've got assets that are left over afterwards, I presume they would seek to sell those assets into the marketplace.
And
I
Jean, I concur. I agree with what Eric said.
So
Okay.
just,
I-
can I just
I
clarify
just-
something? So Eric, you're saying that the CCA would then try to resell those power supply contracts into the market?
Yeah, in your example, they were not a bankrupt entity, so
Right.
the contract is still valid. They're still paying the entity. They have an asset that they don't need for their own compliance needs nor for their own hedging needs. So presumably they are going to try to monetize that asset into the market.
Okay, thank you.
I just want to clarify, when we say voluntary return, that means that the customer is opting to return to the utility. It's still an involuntary return if the CCA is returning the customers to so the voluntariness state of it is about the customer's choice to return. Just for clarification.
The distinction being made previously was was basically one of a soft landing versus hard landing for a CCA.
Yes. Really quick, I wanted to cover the messages, the points that came in online, and then I'll turn to you, Matt. Scott Olson stated to clarify Edison's statements on the POLR IRP obligations. If the failing LSC has met its IRP procurement requirements, the POLR receives full credit. Now I'm actually wondering if this was a statement. Yes, this was here. Sorry, to clarify Edison's statements on POLR IRP obligations, if the failing LSC has met its IRP procurement requirements, the POLR receives full credit for the procurement performed by the failing LSC. Is this only for projects that have already come online? What about projects that have a future COD date after the LSC failure?
Yeah, I can take that. For the most part, yes, it would be for those projects that have already come online. For future dates, I would say if the project actually shows up, that those should be counted towards meeting the obligations. If they don't, then they wouldn't. I think the reality of it is depending on how close the failure is to when construction is completed. So if there's any sort of significant time in between, it's probably unlikely that the project's going to get built, which on essentially a merchant basis moving forward. They'll have to try and recontract or abandon the project. So in my mind, it's whether the capacity actually gets constructed. But for I think all intents and purposes, it's most likely going to be only the online resources.
And so does the utility want to take on, it does not want to take on the completion of these projects, or they would do their own contracting for new resources?
Yeah, so I think this kind of dovetails a little bit into the other discussions. I think there's on a forced assignment, there's all kinds of issues. Never mind, whether we can operationalize the terms that have already been agreed to. In certain circumstances, actually results in increased costs just as likely if the market's moved the other direction and we can procure for a less price, or if we're already long, we can use existing resources to satisfy that obligation. There's a whole host of reasons why an automatic assignment is not a very, would not be beneficial to us. Never mind all the complexities around bankruptcies and whether it can actually occur. And then finally, I think ultimately what we're really talking about, setting all that aside, is having the POLR guarantee the CCA contracts, which is not something we'd be looking to do, and also doesn't come for free as well. So I think that structure is really problematic. Now, on the ROFR side, I think you have some of the same complexities around operations and what have you. And an option for us is, potentially beneficial, but I understand all the complexities and challenges a CCA would have in implementing that and the impact it would have on the market there. So just sort of recognition on our part of what that means.
Okay, there's another comment from the messages from Cal Advocates for Valerie. If the state imposes contractual POLR related terms pursuant to the Commission's state constitutional authority and the POLR and RA statutes, don't those terms effectively become encumbrances on the executory contracts, even if the contracts are the property of the bankruptcy estate?
So, yes, I think that's correct. But I think that the issue then becomes, to the extent that there's a conflict between those contractual terms and the bankruptcy code provisions that provide for the company in bankruptcy to control the assumption and assignment process, you potentially have a conflict there that implicates the supremacy clause. And so then the question becomes, does the state law preempt what's already provided for in the bankruptcy code to create an exception in that circumstance? And please do let me know if I'm not understanding the question correctly.
I'm not sure I fully understand the question, so I'm not sure I can advise you on that. Okay, if there's no further discussion of that question, let's move on to Matt Friedman.
Thanks very much. This is Matt Friedman with the Utility Reform Network. I'm curious about whether any of the panelists would have concerns about allocating IOU resources that are assigned to other load-serving entities currently, which would be resource adequacy, any IRP backstop procurement, and the voluntary auction market offer resources that were approved under the PCIA decision. All of these resources that are initially held by the utilities allocated to a load-serving entity. The load-serving entity returns its customers. Is there any reason why those allocated resources wouldn't follow those customers back, and why provisions to ensure that those resources come back to the POLR if customers come back couldn't be included in the agreements?
So Matt, this is Eric from Cal CCA, and you'll actually see that in presentation material from Cal CCA later on. And it really, not trying to address the question of costs and the allocation of those costs, but the question of whether or not there are resources available to meet the reliability needs, the RPS needs, both in the circumstance where a customer is returning. And agree with you that there are resources in the cases that you just mentioned that are indeed available to meet those needs. So not getting into the details of exactly how you would deal with costs and the transition of those, but whether or not the resources exist, they are certainly there for those purposes.
Hey Matt, can I want to make sure I understand exactly what you're asking. You're saying IOU portfolio resources that are already transferred to the CCA, and then when they return to customers, those resources coming back?
That's true. That's correct. And that would include also for RA central procurement entity resources that are allocated. So anything where the LSE that is returning the customers to the utility is a recipient of an allocation done by the utility or the CPE, could that allocation simply follow those customers back?
Yeah, and that was, thanks. That was contemplated in the earlier presentation. When the RA obligation switches back to the POLR, it's not just the obligation, it's also the CAM allocations as well, to make it sort of a complete picture. So we would agree, yes, those should be returning. I think what might be a little bit of a gap, although I think they do return because the agreement would be terminated, but there might be a short gap period as voluntary allocations or market offers from the PCIA, the VAMO essentially. But I really think that only impacts a month or two if there's truly an LLC failure, because then we would be retaining those moving forward. from an RPS standpoint.
And would any changes need to be made to the underlying agreements between the utilities and other load-serving entities to ensure a prompt return of the resource to the POLR under such a circumstance?
It'll already be accounted for in the agreement itself. So as soon as payment's not made or a bankruptcy occurs, these are typical event of defaults, then we no longer have to provide quote unquote the product. And so in that case, we would retain it immediately. There might be, like I said, like maybe there's and these things sort of stretch out a little bit. There might be a month delay there, but I think for the most part, you're getting the vast majority of the benefit returning back to the customers.
Okay, so in the event of a bankruptcy, that would be automatic default, even if the bills continue to be paid?
On our agreements, bankruptcy is an event of default that would allow us to terminate the agreement. So once you terminate the agreement, they're not required to make payment, but we're also not required to deliver product.
Okay, thank you, Bill. I appreciate that. Really helpful.
Yeah, no problem.
Okay, Erica Brown, did you have something you wanted to ask?
Dina, can you hear me?
Yes.
Okay, good. Sorry, it took a minute to get off mute. I'll say to the questions about the resources returning, I think PG&E was looking at it on a product by product basis. I think for the attributes that flow through CAM, so traditional CAM and then also CPE, I think that adjustment will come back. I think we were hoping to take a little bit closer look at the VAMO framework, because I think there's some concern that if there's non-payment, then those attributes go back to the pool to be reallocated. So we just want to make sure that the framework itself is set up correctly, so that we can potentially use a contractual mechanism for them to come back to POLR, if that makes sense. So I don't know if we need a change to the VAMO framework, but subject to further check, but we were a little bit concerned that it would go to the pool and then be reallocated to everyone instead of going back to POLR.
So I wanted to, recognizing that there's a lot of debate, particularly on the side of the LSEs, in response to this proposal to do contract reassignment or potentially right of first refusal clauses. Going back to the broader objective of this panel, we're looking to establish a plan for ensuring continuity of service, particularly at a reasonable cost. Our only previous experience with this kind of event was the California energy crisis. And under that, the market was different during that time. But in order to stabilize the market, the state had to go out and procure several $1 billion of DWR contracts in order to bring enough resources into the system and stabilize the energy market. And so short of using state authority to do direct procurement, we want to talk about what other alternatives there would be for ensuring resource availability in the event that these the customer return is under conditions that would not make it easy for the utility to reabsorb these number of customers back into their service. And so I want to open it up and ask people, what other ways would we approach this problem?
So Dina, this is Eric from CCA, and if I might, what I would suggest is that the first thing we ought to be doing is taking a look at how the circumstances today differ quite dramatically from what happened during the energy crisis era. During energy crisis era, not only did the utilities divest and they were the primary load serving entity, there was a relatively small amount of direct access at that point in time. But not only did they have to divest, they were also ordered not to do forward procurement. They were to buy and sell everything out of the spot market. Today, in the other hand, we have the utilities who are regulated in terms of their forward hedging. You have other load serving entities that are doing forward hedging. You have all the load serving entities with IRP requirements, as well as RA requirements, as well as RPS requirements. So there is definitely a forward view of when those things are potentially going awry that you did not have in the market at that point in time. So I think it is a very different set of circumstances today in terms of knowing and being able to foresee that type of a difficulty. So that I just wanted to add that to the discussion that the market today is quite a bit different than it was 20 years ago.
If I could also add, we continue to have difficulty, Dina, as you know, with the premise, right, that there won't be resources available to the market because number one, RPS isn't an urgent resource. It can be done over time. It's not, you know, do or die tomorrow. RA, if the RA showing has been made, presumably there are enough resources out there or they will have been backstopped by the CAISO. So there is capacity out there. The question is, you know, who's going to get it and at what price. So the availability isn't the problem perhaps there, but more the price. And then with the IRP, again, you've got control over that. You've ordered procurement, you're monitoring compliance, and you'll have a general sense of what's going on. But even if you were to have a shortfall because an IRP project isn't coming along, it's not the whole portfolio that's the problem in rebuilding. So, you know, it's on the margin.
That all being said, we are seeing extreme capacity constraints right now. I think that actually I'm going to turn this over to Molly to speak a little bit more about this problem. And so I'm gonna pass it on to her. Molly, can you? You're on mute there. Molly, you're still on mute. I think you need to unmute. I still don't seem to be able to get Molly on. So I will keep speaking to this. Yeah, I'm trying to. I sent you a request, Molly. You need to now click on mute. David, are you able to unmute Molly?
Can you hear me?
Yeah, now we can hear you.
Great. Hi everyone. Okay, I'm getting an echo. Are you getting an echo, Dina? No.
Try now.
Okay, it's still.
Yeah.
Yes,
Now
we
try.
I don't know why I'm getting an echo.
No,
are you guys getting an echo?
Not an echo anymore. You can go ahead.
Okay, great. Well, I'll just talk to talk when you're listening to yourself speak. Shoot. Okay, I want to speak about LSE contracting, but let me see if I can switch my audio. I'm so sorry, guys.
Meredith, are you on the phone and on the WebEx?
Hey, Dina, to fill the time here, can I make a comment on your last point?
Yes. Yes.
Thanks. So yeah, this is Frank DeRosa again with CIA and LSA. Regarding this question of shortages, I mean, it's a great point that we have a shortage now as well. But this question about should the contracts be assigned? I mean, it is a tough question. I totally understand, Edison, Bill's point about wanting flexibility and Eric's point about the CCAs wanting flexibility in their contracting. I'll say that even the Commission has said that the procurement process by the CCAs has been rigorous. It's a very competitive industry, and there is oversight by the governing boards of the CCAs. So I take that to mean that the contracts that have been entered into have gone through a rigorous evaluation process. I think it really is up to the Commission to decide what how much risk it wants to take in assuring a steady supply of power at a reasonable rate. So, I mean, I really do think that's the question.
Can I ask Frank, this is David Oliver with CalCC, Frank, or maybe any other developer, has there been any other instances, maybe outside of California, within California, where this contract assignment has been written into these other kind of contracts, so that there's a third party POLR or IOU kind of backup?
I'm not aware of any. Obviously, of course, these contracts are all confidential, so typically we don't talk about contract terms even among ourselves in the associations. You might ask that of Bill and Eric, and they may or may not be able to speak about it on this call.
Sorry, I go ahead. I wanted to bring it back because we didn't really have a chance to discuss. Okay, respond to Evie's point, and I think that Molly is available now. Molly, do you want to try again? Are you there, Molly?
Let's see.
All right, I'm just going to speak to Molly's point. We have, there is tens of thousands of megawatts of procurement that needs to be done in the next several years in order to meet our procurement requirements. And if that procurement is not online, and we're not talking one or two small projects, we're talking collectively about the ability of everyone to do it together, we will have a shortfall, which is increasingly tightening the capacity and creating market power. And our objective here is to be addressing those problems. And so we're just like, the point of this discussion is to be examining what those problems are and discussing them.
Okay, Dina, this is
Yeah.
Can you hear me now?
Yes.
Oh my God. I have no idea why that was such a challenge. Okay, after 2 years, it's exciting every time we get something to work on WebEx. Okay, so I just wanted to jump in and talk a little bit about what's under contract, what has come online, and what is coming online, because I think the order of magnitude is quite astounding, and it's really important for everybody to kind of level set as to what the situation has been and is going to be. So in the past 18 months, basically since the rotating outages in August 2020, the state has brought online in the CAISO area, and this is including work done by IOUs, ESPs, CCAs who've contracted for a variety of resources. We've brought online collectively nearly 100 projects for a total of about 6,000 megawatts of nameplate, which roughly 3,000 megawatts of NQC. It's an extraordinary amount of clean energy resources that have been brought online to meet reliability. And I mentioned what we've done just also in the context of we have extremely large regulatory requirements for new resources. The regulatory requirements for new resources stem from two orders, one in 2019 for 3,300 megawatts and one in 2021 for 11,500 megawatts. Collectively, that's 14,800 megawatts of new resources by 2026. As I just mentioned, we've brought online about 3,000 megawatts of NQC to qualify towards that roughly 15,000 megawatts of requirement. And we have been closely tracking contracting and resource development over the past 18 months, and we're going to continue to do that. And what we've seen is that there is an extraordinarily large amount of contracting underway. However, because there are so many entities, like the market is so fragmented in terms of who is responsible for these requirements, and there are so many different contracts at play. It's very difficult to discern whether or not we will make it. We appear right now to be a wee bit long in terms from a regulatory perspective, meaning over contracted or over delivered based on just like 1 year. However, there is no time to get excited about that because the regulatory requirements in the next 3 years are very, very steep. So we, like I said, we've brought a lot online. We have a lot under contract. I think we could bring online, if you, in terms of contracting, we could see another 5,000 megawatts of new NQC come online in the next 2 years. However, the regulatory requirements it's about 800 megawatts this year. It's close to 3,000 megawatts next year. But in 2024, in a single year, there's a requirement of 6,000 megawatts new NQC. So everything about being in a long position right now, relative to contracting and relative to regulatory requirements, that's nice, but we don't have a lot of clarity as to whether or not our LSEs will collectively make the requirements that will be cumulatively enforced by 2024. It's a long-winded way of saying, it's great that all the LSEs are doing such incredible work to do contract with a lot of different projects, with great diversity of projects around the state. 35 different counties have projects in them. But we also have seen a lot of contract delays due to COVID, permitting, traditional permitting challenges, traditional interconnection challenges, all the development challenges that projects face. So, and now they're doing it in a pandemic context as well. So anyway, long-winded way of saying, there's a lot going on, and I hope all of this context of this POLR conversation can just keep in mind, just the enormous magnitude, just in terms of the number of contracts and the number of megawatts that are coming online in the next few years, and may not come online. The last thing I just want to close with is saying, the midterm reliability requirements of 11,500, those come with penalties if the LSEs fail to meet them, not just backstop penalties like in the 2019 procurement order, but backstop penalties and penalties for failure to procure. So that complexity of the backstop and how that will all work has not been completely sorted out from a regulatory perspective, and that just is highly closely related to this whole POLR discussion. So that's why I'm listening today. So thanks, Dina. Hope that makes sense.
Okay, thanks. And Evelyn, you wanted to respond.
Yeah, I mean, I think we're mixing two issues here. The first one is the IRP process working? And are the projects getting built under IRP that are supposed to be built? And to me, that seems like an issue that we should be addressing in IRP, not in the POLR. The second question is, how does the IRP obligation transition? And I think Bill explained very well what we're proposing in terms of transitioning that requirement. So I just see those as separate issues. And I think if there's an IRP issue, that's where we need to be addressing it, not here.
Except if the LSEs fail, that is the purpose of this. And if the LSEs fail, it will have an impact on our ability to make those procurements.
Yeah, and I think what we suggested in our outline, the LSEs, is that, you know, you transition the obligation on the date that the customers come back. If something's been built, you count it. If it hasn't, the obligation then will transition to the IOU as POLR in this case. And I don't know, Bill, I see you have your hand up too.
Yeah, so I agree with Evie. I think it really is, we're conflating issues a little bit. If you think about the risk around procuring 11,500, is not, in my mind, it's not necessarily LSE failure. It's coming up short, not doing it, doing the wrong resources, or contracting with stuff that comes on late. And Evie's right that it has more to do with the IRP and how do we go about with backstop procurement and what the rules around that. The other risk in my mind is a little bit smaller. I do want to point out a couple of things though. At 11,500 megawatts, that had built into it acceleration as well as buffer for all those things I described, including, and in some cases, which I think is just a flavor of it, which is CCA failure, which doesn't not result in the capacity being built, but is delayed the same way someone didn't make their requirements would be delayed as well. And so with all that cushion built in, right now, I mean, the IRP shows us at 2026 at a 1 in 1,000 LOLE, that we have quite a bit of cushion built in there to help us realize these things. I think what's being discussed here is having, you know, commercial transactions where a CCA and a third party enter into both sophisticated parties on both sides of it, having the LSE then step in and then guarantee it on top of it. In my mind, just doesn't make sense to me that we're out there guaranteeing contracts for other entities that have the obligation to do this in the first place, and that it's just from that perspective, it's bad policy. And I'm not sure it solves it at the end of the day with the bankruptcy issues, with our ability to operationalize. I'd ask also, like, does it necessarily mean that especially if we're like say months away from something being constructed, and we really do see a reliability needs. That, you know, the whole collectively we're coming up short. Does that mean the resource goes away necessarily? It doesn't mean that we don't have the ability to go contract with it or negotiate with the counterparty. We can still go ahead and do that. It's not like that doesn't happen. What this does is forces us to do it regardless of a long position, regardless of whether it's needed, regardless of the price, and also has us guaranteeing contracts that we shouldn't be guaranteeing.
Christian has their hand raised.
I'm with Cal Advocates, and we're here for bundled rate pair interest. So I just want to take the opportunity to respond to a few things that I heard from some of the panelists. Starting with Frank, some of the things that you pointed out, you had said, you know, CCAs have board review of procurement, and that's very robust. I think we see it a little bit differently. We had followed Western Community Energy's board discussions, and it really seemed to us that the board was actually quite surprised at how their procurement needs developed leading up to and into their bankruptcy. That was largely an artifact of staff working with the third party to accomplish procurement goals, and then going to the board, making representations. Here are forecasts, and those forecasts didn't pan out. So I would question, you know, that portrayal. And Frank, you also had highlighted concerns about, okay, what if a contract is sold and becomes an export? I think from our view, this is actually the outcome that we are really trying to avoid here. Other balancing areas, LSEs, many of them are demonstrably well behind their own, you know, equivalent resource adequacy obligations. I can think of one that recently publicly stated has a negative PRM for the coming summer. That's deeply concerning, and that is a source of tight market conditions. So that's where we have this availability problem. Those LSEs may be wanting to snap up a contract that becomes available, and if we do not have a robust continuity of service plan in place to ensure that contracted CAISO resources of a failing load serving entity remain available to the CAISO, then we're losing the must offer obligation that keeps those resources in the CAISO markets. Evie Call had brought RPS into this and said that's not really a need here. I think that may be true in the near-ish term, but there is definitely going to become a point where RPS energy is necessary to charge the gigawatts and gigawatts of storage resources that we are bringing online, and that is resource adequacy need. The RPS itself, if it's solar wind, of course, it also has its own RA value, and we don't see LSEs by and large going out for energy-only resources. We see them looking for SCDS resources that simultaneously provide RA and RPS and whatever other attributes. And we need the whole production profile of that resource to get the ELCC to count for the RA. So it's not necessarily appropriate from our view to be segregating RPS totally out of the picture and downplaying that. And with respect to what Evie Call was saying about the CAISO can just be backstopping this, I think the CAISO has made it clear, if they are looking at an RA deficiency as the grounds under their tariff to do that backstop procurement, then, they need in the first place LSEs going in and showing their RA resources on their RA supply plans. And so what happens when you don't have the LSE? Where does that resource go? It has to go, in this case, I think we're looking at the POLR, picking up those contracts, picking up those resources. Now they're on the POLR's plan and can be shown or not to the CAISO. But if they're not going to be picked up by an LSE that is showing them to the CAISO, how is that backstop actually going to work? What is the authority under the tariff? I think that's an outstanding question here. And then finally, Bill, some of the things you reiterated, I think you framed it as you don't want to be in the position of guaranteeing CCA contracts. And I think that is something that we at Cal Advocates would say, we hear you and we are sympathetic to that, but the POLR statute itself, it makes this question fundamentally one of, do we formalize the use of the POLR balance sheet essentially to buttress the entire system through CCA contracts, or do we not do that? And if we formalize it, then we have an opportunity to say, what is the risk that would otherwise fall to bundled ratepayers? What is the cost associated with that risk? And is that consistent with Public Utilities Code section 365.2, which prohibits the Commission from approving CCA procurement plans that would violate bundled ratepayer indifference? If we do not have this discussion, if we pretend that the POLR statute doesn't effectively cause IOUs as POLRs to leverage their balance sheet for CCA procurement, we're probably going to see some of those costs fall back to bundled ratepayers, and that is why Cal Advocates is going to be weighing in here, and we really want to avoid some of those outcomes. With that, thank you all very much.
Dina, I think, we've gone about 5 minutes over the time.
Are there any final comments?
Yes, I had my hand up here. I just wanted to say in response to Christian that I didn't say it wasn't necessary or important. I said it wasn't urgent to get RPS solved. And if you're talking about having the resources to charge the batteries that are being built, again, that finds us back in the IRP, right? That's where that's happening, that we're building those resources to charge the batteries that are in the IRP. So it ties back there.
And Dina, this is Eric. One other thing that I would like to mention, I see it in the chat and I also heard it from Frank, and I understand this is something that Cal CCA had advocated for in the first go round of this, and having been silent on it since, could be construed that we are still advocating for it. And this is the issue of whether or not another CCA could take over for customers in some sort of a 60-day safe harbor window. Cal CCA has abandoned that position. We don't think it's feasible. We think that if a CCA wants to take over for another CCA through a joint power agreement, something along those lines, that should be done before there is any default of customers. If otherwise, the customers are going to return to utility bundled service as described in the first section of this discussion. And if the CCA does ultimately want to take over those customers, then they'll have all of the rules and obligations that goes along with that with a 6-month pre-notification before any of that were able to happen. So just to make clear, we're viewing this as either you're going to work ahead of time so that the default never happens and the deregistration process never happens and the load is not returned to POLR, or if it is, it goes to POLR and then to bundled service before it would be eligible to go back to DA or CCA. So just wanted to make that clear because I know we hadn't said that between the first workshop and now.
Okay, and just to be clear, the possibility of customers returning to another CCA is to be considered in the next phase of the proceeding.
Hi, this is David Matusiak from PG&E. Can everybody hear me?
Yes, we can hear you.
Okay, great. So one thing that we wanted to speak about today was liquidity needs, and this has come up intermittently throughout the presentation already. But if you could please go to the first slide. Great. So once there's a POLR event, there will be an immediate transfer of load back to the POLR. And one of the things that needs to happen immediately is that the POLR has to start purchasing incremental costs for the returned load. So for example, not only does the POLR need to start purchasing energy, it may also need to start purchasing RPS and RA resources. And so what that requires is a large sum of cash in order to make those purchases. Right now, there's a delay between when those purchases are incurred, when those purchases need to be paid for to the CAISO, and when the utility needs or will begin to receive the revenue from that return load to pay for those costs, because the utility system works in arrears. So right now, the current FSR calculation is inadequate to provide that sort of liquidity. And the utilities acting as POLR hold aside large sums. Those sums are used exclusively for these POLR events, at least for PG&E. And what that means is that there's a cost to holding that liquidity because that sum of money could be used for something else. And ultimately, those costs are transferred to bundled customers. So PG&E's procurement pool concept is intended to provide sufficient cash flow for the POLR for the 60-day period in between when those purchases start to occur, and then eventually when the POLR receives those revenue for that. So if you could go to the next slide. At the top, you can see POLR actions. So prior to day one, the POLR determines liquidity needs. The POLR would have to receive authority from the CPUC to access that pool. And then the POLR would begin serving those returning customers on day one. Starting approximately day 15, the POLR starts to pay those CAISO invoices that are incurred to serve that load. But if you look at the bottom, you then see customer actions. So around day 30, plus or minus, the customer will be receive the service bill from the IOU that's acting as POLR and start to remit those payments. So in most circumstances, if you're being billed on day 30, it's not until day 49 that the customer would pay the bill. That'll range earlier or later depending on the billing cycle. And that doesn't include delinquencies, which at times can be pretty noteworthy in the billing cycle. During the first 60 days as well, the customer could elect a new service provider. And if it doesn't, then that customer would ultimately go to the IOU. But really, it's the first 60 days that imposes a problem. And right now, the FSR calculation is a long run avoided cost calculation. So it nets expected revenues against expected costs, but it doesn't account for any of the temporal aspect of that, which is what this proposal is looking to mitigate. If you could go to the next slide, please. So this slide is an example of how such a scenario might work, starting at the beginning, where we try to establish the posting for each individual LSE. So to mitigate the need for upfront liquidity, the pool is intended to cover approximately 2 months of Polar service. But right now, the way that PG&E is proposing it is that the posting would only cover 2 months of incremental energy costs. In the year -1, the year before the posting is due, we would use inputs from the existing ERA forecasting process to determine what the departed load for each CCA would be. And then we would take the estimated 2 highest months for both on-peak and off-peak and multiply that by the PCIA benchmarks for energy. The CCA would be expected to post that by the end of the year for the following year. It could be through 2 different means. One, the CCA could post in cash, or 2, a pooled letter of credit arrangement for an amount equal to the sum of each participating CCA's contribution. Below is an example for CCA 1. The CCA hypothetically would have its 2 highest months in August and September, and would have an on-peak load forecast of 140,000 megawatt hours and 135,000 megawatt hours, and then also 105,000 megawatt hours for off-peak in August, and then 100,000 megawatt hours in September. Each of those values would be multiplied by an average on-peak price or off-peak price based on the PCIA benchmarks. And then we create a total contribution. And that total contribution would be 19,555,000. One thing to note is that that 19.55 value is not really going to be the actual cost to serve load for the 2 months if that load returns to the Polar, for a couple reasons. One is that these values are based on benchmark energy prices. And in the event that there's a Polar emergency, it's been pretty well established that most parties of the proceeding believe that that would happen during high stress, high market, expensive market conditions. And so the incremental cost to serve that energy actually may exceed or would likely exceed the benchmark prices for the forward estimates and the forecasting of what it would require to serve that load. And then the other aspect is that this calculation does not include RA and RPS, both of which are potential incremental costs that would need to be met, but which would be resolved through the pool proposal. So if you could go to the next slide, please. So this slide is a little bit complicated, but it goes through an example of what would happen during a Polar event, how the Polar would access the pool and then replenish it. So in step 1, we have been notified that there would be a Polar event, and looking at the departed load and estimated costs, the Polar here in this scenario determines that there would be a need for $30 million for the first 2 months. To the right, you can see a small ledger. The total procurement pool in this scenario would be $200 million. The failed CCA would have a contribution of $19.55 million. The delta between that and the 30 million is another 10.45 million, excuse me, which the Polar would access for upfront liquidity, leaving an ending balance of $170 million in the pool. Then the Polar would start to provide service to those customers for 6 months. The second ledger in the bottom left includes all those different entries. So the front line is the liquidity for the Polar, and then the 3 below that are the estimated costs. So energy costs, RPS, RA, that's 92.8 and $26 million. So total costs of $126 million to serve that load for 6 months. There would also be estimated billed revenues of $101 million. So once you net those after 6 months, there would be an ending balance of $5 million. However, this calculation does not include the 10.45 that had been borrowed from the pool. So the first step would be to remove the $5 million from the balancing account and transfer it back to the pool. The ending balance of the pool has to be 180.45 million to maintain indifference, which means that there would be an additional 5.45 million owed to the pool. The expectation would be at this point, there would have to be some sort of true-up and rate-making process with the CPUC. And while it reviews the Polar event, we would also have to establish an amortization period depending on the number of customers that are returned, as well as the difference of that much money needs to be recovered. And that would be recovered in a monthly flat non-bypassable charge on bills. exclusively on the customers that are returned with the load. If you could go to the next pool, next slide, sorry.
I'm sorry, did you say that was the last slide?
Next slide, please.
Oh, I'm sorry.
Okay, thank you. Yeah, so there's a couple things that we wanted to discuss as well with everybody on the workshop and some things to hash through. But essentially what we're looking to address a need for is liquidity. Right now, PG&E bundle customers pay for that liquidity and carry the costs, and that constitutes cost shift. And depending on how the pooler is, the incremental procurement costs might be disproportionately higher or lower than its average costs in the cost of course of business. And so that's something that would not necessarily get addressed in a just modifying the FSR as it is, but the pool would help address for that cash flow. And then also providing shared services provides benefits to the other CCAs by reducing the collective costs for potentially what needs to be posted in order to provide a greater runway for the POLR, and also increases bargaining power when it's looking to potentially set up a letter of credit agreement with a bank. There are some other considerations, for example, what procurement costs should be included to establish the procurement pool. There needs to be a bit of a give and take between what the POLR needs to incur and also what can get posted collectively in the pool, and what cost estimates there are. And so that's something that's worth discussing. Another thing that we've tried to figure out and is an open question is whether that procurement pool would be established at a TAC level, like would each IOU have its separate procurement pool to the extent it's acting as a POLR, or that need to be statewide, and there are pros and cons of each. And then additionally, like who would manage to be the beneficiary of the pool? In some scenarios, it might be best if the CPUC, for example, would be able to manage that, or if the CPUC was the one that would give authorization to allow the POLR to access that pool. And then the other issue is the beneficiary of that pool. So for example, if it's a TAC level pool, would it just be the POLR in that TAC area, or would there be other entities that could access that in the event of emergency? Or again, if it's a statewide level pool, how do you set up the flow of responsibility between the different POLRs, and how would you ensure that only the appropriate POLR is accessing that when needed? So those are all of our sites for today. And I think we're going to take questions after the last presentation in this section. Is that correct?
Yes.
Yes.
Okay. Sure.
So I think Eric Little with the CCA is up now.
Yeah, thank you, David. Let's go ahead and go on to the next page. So I do know that there was some information about having a separate meeting on FSR, but I think it's difficult to talk about the question of whether or not we should move to this pool approach without really examining the fundamental question, which is the FSR sufficient to be able to recover those costs? And if not, then what? So if we can go on to the next page. CalCCA has taken a look at this pool concept proposed by PG&E, and our analytics of it reveals this graph. So you start off with all of the CCAs providing in at 2 months worth of forecast costs with no revenue offset. Based upon information that CalCCA has about the CCAs, that's $1.4 billion. That's a gigantic price tag. From what we understand, that insurance pool will be provided by a letter of credit or cash. The POLR will then have the ability to draw upon the defaulting CCA's FSR or others to be able to meet any of their liquidity needs, and will then replenish that pool after the fact with any revenues that they have received. So that seems consistent with what we just heard, but there are a number of concerns with this. The first one is $1.4 billion seems excessive compared to the issue just raised of they're going to start paying ISO costs before they start receiving revenues from customers. And while I understand the concern, I don't know that 1.4 billion is the solution to that, as much as looking at what financing costs of that money really realistically looks like. The second question that we have is, is there a fair process to be able to draw upon a letter of credit in that situation? This becomes very confusing, right? How do you deal with that? Is it going to be that once you've exhausted the letter of credit from the deregistering entity that you hit everybody else pro rata? Do you pick one at random? Do you select the largest? How do you go about that? And then I think there's also a question about, will banks actually offer anything like that? I mean, I'm just trying to imagine going to a bank and saying, I'm going to post a letter of credit that may get hit if I deregister, and it may get hit if somebody else deregisters. So you're providing me with a letter of credit against somebody else's risk. And so there's a significant question about, what does that kind of a letter of credit cost? Because it's not strictly based upon my risk. It's based upon others' risks. And not knowing how it's going to be called upon, I don't know what the cost of that is going to be. I think the next concern is, I'm still on the prior page, sorry. I think the next concern is, why are we exempting any entity, quite frankly, from posting to this? In the circumstances that we've been describing here, a lack of capacity that is driving costs really high, where not everybody has access to that additional capacity that's needed, everybody's costs are going to go up in that situation. So I'm not sure a default by just CCAs is relevant here, but a default by ESPs and possibly even by IOUs seems to be at risk at that point in time. And so having this pool funded strictly by CCAs doesn't seem quite appropriate either. So if we have this concern about this instantaneous outlay of cash, I guess the other question is, the utilities also have a PCIA portfolio as well as a CAM portfolio that is in that ISO market that's also earning revenues at the same time frame that those bills are coming due. And if prices are high in the energy market, those resources are going to be getting those high prices as well. So there is an offset there also. So we've got some concerns about the PG&E proposal. It's not that a pool in and of itself is unworkable, but this particular design doesn't really appear to be something that would be a better solution than really just looking at FSR to determine if there's anything there. So if we can move to the next page. So on this one, again, we've had some discussions with the IOUs on this, and I think that on the first bullet point here, there is quite a bit of agreement that when you go to calculate an FSR or a reentry fee, that using recent benchmarks for prices is an appropriate thing to do. It's the most recent, the most accurate that we have at that point in time, and utilizing that would be more informative than using an old piece of information. There are some things, though, that we think should be considered in addition to this. This was discussed a little bit earlier as well, and that is, there are these CAM allocations. So when I'm calculating an FSR and I've got an entity that says, say they have 1,000 megawatt RA requirement, but I'm allocating to them 100 megawatts of CAM resources. Well, the IOU is only going to need to procure 900 megawatts of actual resources coming back, because they're going to get the 100 megawatts of CAM back as well. And so that calculation, the FSR calculation right now, doesn't appropriately account for that. So we need to think about things like that. We also need to think about other things in the revenue forecast that we're looking at. So for example, and there's a number of them here, right now we use the average system cost for energy, the generation rate for the utilities. But that's only reflective if the set of customers that are returning are representative of the average. And generally, the residential classes are paying the highest and business classes are paying the lowest. So if what's being returned is something with a high percentage of residential customers compared to what the utility serves, the revenues that are going to come back are actually going to be higher than that forecast based upon a system average. So perhaps we ought to be looking at things like classes of what is actually being served by that particular CCA. If there's any rate changes that have been approved, so either a GRC or an ERA proceeding that has approved rates looking forward at that period, if those are going to be in place, that should be calculated within that FSR calculation as well, not the present rate that is in effect, but what is going to be in effect at the point in time that you're concerned about customers returning. Seasonally differentiated rates. We know that energy costs are typically higher during the summer than they are during the winter. And most of the rate schedules for utilities have that type of differentiation in them, not all. But again, we go back to using a system average, which takes winter and summer as being, averaged into that total. If we're worried that this is generally going to tend to happen in the summer, and if summer rates are higher than winter rates, then we are discounting the amount of revenues that we would expect to see. And then the last one is the PCIA interaction. And this one is very, very complicated. The PCIA mechanism is really a difficult one to understand with what happens in these sets of circumstances. There has been a discussion about removing the PCIA from the bundled rate component on return in its entirety. Not sure that's the appropriate way to do it. And I think we need to have a much more detailed discussion about what PCIA is designed to recover, what it does recover, and what happens under the event of a deregistration, and what really is incremental revenues and what really is not. We can move to I think it's my final page. So this is the top line here is how we calculate FSR right now, right? We have a forecast of what RA is going to cost. We have a forecast of what RPS is going to cost, forecast of what energy is going to cost, and an admin fee. Those four combined make up the cost side of the equation. We subtract from that the revenue that we expect to get back, and the difference between those two is the impact to the FSR. And the reason I say impact to the FSR is, remember, that calculation can come up negative, in which case you have to post the minimum 147,000 presently. So when I say impact to FSR down below, I'm not trying to say that is what the FSR will be. I'm saying that's the effect to the calculation. So down below, we have two sets of items here. The ones in blue are things that have been discussed before that we have heard throughout this proceeding. The ones in green are items that I somewhat discussed on the last slide that haven't been incorporated to this point in time. So on the left-hand side, the items in blue, the updating of the benchmarks, which I had discussed, and the removal of PCIA, all have a tendency to impact the FSR in an upward direction. And the numbers that you see here are an example. They're an illustrative example of a CCA. And in the case of that CCA doing that calculation, the total was an increase in the FSR impact of 126 million, which is significant. But we are neglecting the other side of that, which has a tendency to reduce those types of costs. So that RA net of CAM, again, if I take out those items that are being allocated through CAM, knowing that that resource is going to be available for that load as it's returned to a bundled customer basis, then that's fewer resources that I have to go out and procure. The seasonal rates, as I had mentioned before, again, this is likely to happen in summer. That's our general theory. And in taking a look at differentials in seasonal rates and doing our own calculations and estimates of what that means in terms of system average, we believe that it would be a reduction in the FSR impact if you accounted for the summer rates differently than just an average. The class rates, again, looking at this specific example, they do not serve load that is on average just like the utility. They do indeed have more residential customers than the utility does. And so if you look at the rate classes and parse that through, you see another impact that is a reduction to the FSR. In total, those would tend to bring the FSR down by 110 million. So if you considered both of those at the same time, 126 up, 110 down, it's a $16 million differential in FSR impact. So I think when we start talking about FSRs and changes to these things, we really have to account for all of these issues. I know that there's been an argument of let's make the FSR more accurate, notably with the benchmarks. Well, if we are going to make it more accurate, then let's look at the entire equation and determine if the entire equation is indeed accurate. And if it's not, let's talk about those changes as well as we go through this process. So that's, I believe that's the, oh, I'm sorry, I do have one more slide if we can move on to that one. So this one slide really kind of reiterates some of the points before, and it really gets down to the first two items are really trying to address whether or not resources will be available, right? The concern is, will I have resources for resource adequacy? Will I have resources for RPS? And the first two bullets really deal with that. The answer is yes, there will be. It may not be the complete set that you're concerned about with the having assignability of contracts, but we do have to remember that there are resources that are going to come back. And those are the CAM resources, and it's the resources that were unallocated in VAMO that could actually be deployed by the provider of last resort that are also available. So there are resource adequacy resources in CAM. and increasingly so with the central procurement entity. And there are RPS resources that the POLR would have access to through the unallocated VAMO or unsold short-term VAMO. And then the final one is this concern on PCIA about the current calculation and needing to account for the incrementality of those resources. I think the other thing that we need to think about there is that those resources also in the market are achieving higher market prices. Back to my earlier point that yes, the utility is seeing higher prices in the market, but the utility is also seeing higher values for their resources that are bid into that market. So there is an offsetting effect. I think that is it for my presentation material. So I'm open for questions.
And I want to clarify before we get into the discussion for this panel that we did not scope into this workshop discussing and having a full discussion on what changes are needed to the FSR. So we'd like to keep this conversation focused on the concept of the need for the utilities liquidity and how to access upfront cash prior to an FSR being approved, because there is a long delay between the time that the reentry fees are established and the customers are returned to the POLR. So, and with all of this being said, we definitely do want to consider what are the methodology changes. But the broader question is, does the financial security requirement, like in its place, would it be able to meet the liquidity for the IOU to operate as a POLR?
Maybe PG&E would have some responses to some of the objections that CalCCA brought up.
I think the main point that we have is that we don't necessarily object to some of the proposed changes to the FSR calculation per se, but that unless it ends up with a number or a pool of liquidity that solves the problem of the POLR having to carry these liquidity costs, it is a bit of shuffling chairs in the Titanic. So we don't, I think there's ways of talking about it that we're very open to. And one of the things that we're looking to achieve with the liquidity pool per se is that it provides that liquidity while potentially allowing each CCA to post something that's smaller. And that was one of the benefits that we were trying to achieve with this pool, rather than having each CCA post the full liquidity that would maybe be needed. And even looking at just the 2 months of energy costs on an incremental basis is already a substantial decrease from what would actually be needed to achieve those goals. I know that there are other people from PG&E on the line as well, so if any of them would like to chime in, I think this would be a good time.
David, thanks. This is Erica, also with PG&E. And thanks, CalCCA, for the presentation. It was helpful to know your position on the pool concept. I think from our perspective, like David said, the pool was a way that we were trying to deal with the fact that there's an enormous liquidity issue. I don't know if we would calculate it as 1.4 billion, but I think we're making a similar calculation, right? How much money does the POLR have to carry to be able to serve load in the event that a CCA fails? And our general position is it's not fair for the POLR to serve it because it ultimately impacts bundled customers to carry that on our balance sheet. When we looked at the numbers, we thought they were very big and thought the pool concept would be a way to make that smaller for each entity putting money forward. I think if it's unworkable to the point David made, that's fine. The CCAs could each put up that money, but our position is that bundled customers should not have to bear that cost. And without getting into the details of the FSR calculation, since it's not on the agenda for today, I think it could be designed in a way that meets that need as well. But it will end up with a big number, like the $1.4 billion. I don't know, Sharok, if you have anything to add. I think we have our finance folks on the phone as well, our risk folks.
He might need to be promoted into a panelist to talk.
He's unmuted.
Okay, this is Sharok Esami with PG&E. I think, yeah, thank you for CalCCA to bring up some of these issues. And I think our perspective is that we reflect quite a smaller portion of serving the load in our territory. So I believe we're going to be more like 50 to 40% pretty soon. So when you look at the size of resources that needs to be reserved for 60 days, we feel that that's quite substantial, number one. Number two, I think same rationale about, you know, telling our banks that, or our financing resources that, you know, we need this money based on, you know, our procurement. But by the way, there's the risk that we would have to also buy this sizable amount for returning customers. So I think that argument about what to tell the bank about who's going to draw on the LC, it also goes the other way, right? So it's a fairly large size, and we need to figure out a fair way to have that reserved for such an event. So whether you do that as individually or as a group, the idea behind the group was that perhaps there could be a way to quantify and assume like what % of that would be applicable for the reservation of the pool. But you know, 60 days of procurement for that size is quite a large sum to procure on short notice for anyone.
Yeah, and I would also like to add, I appreciate the points that Eric, CalCCA, you guys have brought up. And thinking about it in terms of the scale of liquidity needs, and the changes, not specifically what those should be, but in terms of the scale, it sounds like CalCCA is acknowledging that ultimately we could see the FSRs going up substantially in the future, and that the letters of credit that the CCAs have been entering into in the past have been on a much smaller scale. They've been at the minimum, which is, I believe, $140,000, $147,000. And so if we end up, if I'm reading your chart correctly, it looks like this one CCA hypothetically could have an FSR that's $26 million. And that leads me to a couple of questions. First, for CalCCA, my question is, how would that change the CCA's ability to enter into this letter of credit with its institution? And B, if they are entering a letter of credit to be drawn upon at the time that hypothetically they're going into bankruptcy, does that invalidate that letter of credit because the bank now knows the CCA is not in the position to repay it? And then secondly, or it'll be another claim within bankruptcy court. And then my other question is for the utilities, whether that scale of funds in the letter of credit seems sufficient for meeting the liquidity needs of the POLR in this event.
So we might want to try to get Evie on because I think she may have some better ideas on this in terms of what happened in bankruptcy. But my understanding is that WCE had posted a letter of credit and that letter of credit was indeed exercised, and that Edison did indeed gain access to those funds. Recognize that the level of which was in the FSR space, 147,000, I believe. But nonetheless, they were able to access it even during a period of time where they were going through a bankruptcy proceeding. That's my understanding. So I'll ask that anybody at Edison or Evie correct me if I'm wrong on that one. I do want to go back to something else that you mentioned, though, Dina, and that is the notion that this specific entity's example would be a $26 million posting. It would be a $26 million impact to the FSR calculation. I don't know how negative that calculation is today. I don't have that information, so I don't know if it's a posting of 26 million or if it's a posting of something less than that. But I just wanted to be clear in that, because as we know, if the calculation shows that the revenues from generation rates are going to fully recover the amount of costs and it results in a zero or a negative dollar amount, that we don't have them post a negative dollar amount, we have them post a bare minimum. So I don't know what the total net impact to that is, other than to say that the gross impact to the FSR was the 126 million. So, and the other thing too is that in my example, keep in mind that if you took all of the changes to make the accuracy of that FSR posting, it's not 126 million, it's 16, because you should be reducing the FSR by the 110.
So,
Erica, you had your hands up too. Sorry.
Was that me, David?
yeah, go ahead, Erica.
Sure. Without getting into the details of the FSR calculation that CalCCA is proposing here, I think since we haven't had time to review them, I do think one thing to call out is the way the FSR is calculated, even with tweaks. You're taking market prices and subtracting a generation rate. And so you've got a few variables going on. So even with significant changes, depending on the relationship between the generation rate and the market variables, you actually could still end up with a very low number. And so we would be open to changing the FSR to address liquidity needs. But in discussing internally as an alternative to the pool, our thinking was that would need to then have a minimum on the calculation, right? So there would be changes to the inputs and then some minimum to ensure that liquidity needs are met. So I do think there's a path there, but we just need to make sure that we understand how the FSR calculation would turn out under a variety of different market conditions. Dina, does that make sense or answer your question?
So I think with the question, and because I don't want to get into exactly what the FSR amount would be in this example, I think that the question at the moment is what is kind of the scale of liquidity amount that we would be, the utilities feel would be necessary, and is that within a reasonable scale for an individual FSR amount? And
Yeah,
so that's a
so I
question
think
for both the IOU and the CCAs.
Yeah, so I think for us, our thinking was looking at those CAISO timelines and understanding what the liquidity needs are. And so we came up with 2 months of energy. I think, we're open to other ways of looking at it if folks think that that's too much, because it assumes everybody goes bankrupt, or if folks think that it's too little, for example, because it doesn't reflect other costs that will occur, such as potentially RA procurement costs. I think it could go in either direction, but our initial focus was on just meeting the bare minimum, which is those energy needs, and looking at the timeline of when revenues start coming in the door and when we have to start making payments. I think it will be a large amount, which is, why we came up with the pool concept.
And Dina, I guess in considering that, one of the things I think we need to think about is the complexities involved here. So, this discussion has been around the basis of needing to pay ISO bills before revenues flow from those customers. Well, that's true of all bundled load customers as well. And the utilities presumably are being compensated for that. I'm presuming it's within their cost of capital in some way, shape, or form. And I get that this is unanticipated capital that they would need. But if you have the full amount being posted and being drawn upon, and then within your rate design are also recovering for that same differential, the utilities are then recovering twice for that. So I think we need to, if we're going to consider these types of elements, I think there's a lot more discussion around it that needs to be had to understand how those current mechanisms work with a proposed mechanism like this to ensure that customers are adequately protected.
And I do want to clarify, it's not the issue of the utilities being compensated, it's the issue of the cost to bundled customers of us continuing to carry that liquidity. Sorry, Sharuk, did I cut you off? Was that you?
Yeah, this is Sharuk. I just want to clarify a couple of things. I think absence of a significant funds that assures that there's money available for the 60 days, and I think David had a very clear presentation on why it's roughly 45 to 60 days of funds that's needed based on CAISO payment. But it essentially means that the utilities have to provide a free option for financing. Absence of that, and I really can't follow the cost of capital because it's incremental to cost of capital. So the cost of capital assumes what the utility has to procure. So this issue of double payment, I can't quite follow that. The other issue with the letters of credit are irrevocable, so they work technically like cash. The banks have 1 to 6 days to basically comply with the draw request. But one thing to consider with the proposal that David provided, it's not like the bank is going to be told that they're going to draw my LC and that cash may be gone. Actually, the pool concept is that it will be replenished, the same money that if it was used from other CCAs. So that risk is essentially eliminated by that. So just want to clarify that as well.
Can we give Doug Carpa a chance? He's been waiting patiently.
Yeah, thanks. Doug Carpa from Peninsula Clean Energy. And I'm sort of still getting up to speed, so apologies if I have missed some fundamental concepts here. I recognize that risk up front. But if I'm understanding this right, so PCE, we are, obviously one of the more financially sound LSEs in the state. We're, investment grade, bond rating, unlike many other LSEs. And so from our perspective, I'm looking at this and, I'm hearing this concern about a free option that the POLR would be asked to provide this liquidity. And it occurs to me that, and that might incur a cost shift, but it occurs to me that this proposal puts us in exactly that same position, that we would be asked to put up a significant amount of money to provide PG&E with a cost-free option that it results in a cost shift between my customers in San Mateo County and those of whatever other CCA might fail. And I'm kind of curious, why is it that one, I guess, like, why would that be justified that my customers should bear that cost and provide a free option to you? Or alternatively, my other question is, if we're going to put up this money to essentially provide you an insurance product, do we get paid for that? Is there would the POLR pay us interest on that, or how would we get compensated for that? Particularly if there's a loan, do those carry interest, and if so, at what rate? Because it seems to me that what the POLRs actually has at risk and what the amount of the transfer would be is only the interest payment, right? It's only like your, whatever it was, 20 days of interest on this amount for any given CCA. And so it seems like, in a way, we're putting up billions of dollars in insurance product for an amount at stake that is very, very much smaller. Like you're not running up for $1 billion worth of interest in 20 days. Right. And
Yeah. So
there seems to me there's like some fundamental like conceptual problems here that you're taking the polar problems and you're just shoving them onto somebody else and then saying, okay, you guys can bear that. That's fine. I'm like, yeah, I'm not so sure that really makes sense from a policy argument.
yeah, so one thing is that I'm not sure where the $1 billion number came from or the $1.2 billion. So I don't want to speak to that exactly because we haven't seen those calculations. And right now, that cost of capital of holding something aside in the event that an LLC collapses is being held by a different entity, which means that there is a cost shift from a risk of a LLC failure that's going to customers for a different LLC. And if there are costs in the system, as a matter of good policy, those costs should go where they're incurred. And so if there's a risk that an LLC might fail and there would be another entity that would have to step in to support that, then that is a cost that is incurred through doing business. And I think that's the point here is right now, were it not for that CCA, there might not be that cost to the Polar. Is there somebody else from PG&E that would also like to add to that?
Looks like Shirok has his hand up.
Yeah, I appreciate the previous comment, but frankly, those are not our customers coming back. So it's not for our benefit that you need to post a security. It's for your customers' future need. We don't benefit from that posting whatsoever. It's not our customers' benefit. The 60 days required is for that incremental purchases. Our customers have their own liquidity. It's part of our liquidity planning and the filing we do with the PUC. So our cost of capital is reflective of that. When we are asked to now go procure 60 days for customers that are returning, I'm not sure where the logic comes from that we are benefiting or we have a free option. We really do not. We have to go find that money to serve those customers returning. I don't understand how is that a free option to us. That's the obligation of the CCAs to make sure there's enough fund to serve them.
Yeah, no, the problem is the following. Let's say I will invent a new CCA. Let's call it Tahoe. I was just up there last week. So Tahoe Community Energy goes bankrupt, returns customers to you. You have a liquidity need, and then if their posting doesn't cover it, then you borrow money from PCE, right? This pool thing, you end up pulling money out of the pool. That money is money. That's like those customers of the other CCA. They're not my customers either. I'm not involved in this transaction in any way, shape, or form. But then you're drawing on money. That's an issue between that CCA customers and the Polar. I'm not involved in that in any way, shape, or form. And yet I'm putting up money that then acts as a piggy bank for that transaction that I'm not involved in at all to finance that. And so, under this, it looks like you have access to that money, and it's locked away, and I don't even necessarily get interest for that. Like I just I get paid eventually, but the interest costs were just out that. And that's why I say it's a free option for the Polar, because they can essentially force every other LSC state to loan money to them.
I think collectively you all are raising some important points here that it seems like as a series of individual letters of credit, that there does seem to be that doesn't seem like an insurance pool in and of itself. It seems like it's a reciprocal letters of credit. So I'm wondering if there's some other kind of structure that's possible. And I ask this because another way to think about the value of a hypothetical insurance pool that has a different structure than has been proposed would be the fact that the changes to the financial security requirements going forward could lead to the future financial security requirements being in the order of millions, over 10 million possibly for each CCA. And I wasn't sure whether that was going to be seen in itself as a problem to the CCAs. And maybe it's not a problem to you, but the insurance pool seemed like it could potentially be a solution because it could bring down each individual CCA's required cash input into the insurance, the financial security that is required to protect and cover the potential for return. And so I just wanted to reframe it that way so that we don't get completely focused on only the way PG&E proposed it. And I see, Erica, your hand's up, but I think Evelyn has had her hand up for a while, so we should go to her first.
I appreciate your point, Dina, that we need to think about this more broadly, and I think we agree. It's just that PG&E is trying purportedly to address a timing question. And in addressing the timing question, what they're doing is substantially increasing what is now the FSR, because today nobody's posting more than their minimum in PG&E's system because PG&E's gen rate is so high that after that 60 days, they'll have plenty to procure the power for customers that return. So that's why we're at the minimum. It's because of the relationship of their gen rates to market rates. So that's why we're sitting at the minimums. If they're just trying to solve the timing problem, what I hear is financing costs being shifted to bundled customers. If that's the issue we have, that cost shift, we need to talk about that as well. What are the financing costs for that period? And I do want to note that the utilities, and particularly PG&E, have in the past carried balances for the PCIA cap, for example. That's been well over $100 million at times. We eliminated that, so they no longer have that in their liquidity to consider. And they carry tremendous ERA balances regularly. So, you know, we have to put this in context and in perspective to what the utilities' overall cash needs are on a day-to-day basis.
Okay, Erica?
Thanks. Dina, thank you for reframing it. I think, you know, it's clear that the CCA community does not like the pool concept we put forward. We're open to any and all proposals for how to address the liquidity needs. And if that is a higher FSR that covers the liquidity needs, we're fine with that. I think just to reiterate, our overall position is bundled customers shouldn't be carrying this cost, have the same position actually on the PCA carrying of the under collection there. But if there's any way, you know, that the CCAs would want to either just put it all up individually, or if they have other ideas where they could pool it to make in a different structure to make the cost less for each of them, we're open to that because we do acknowledge that the numbers are very big. And we're also happy to provide additional information on what these costs are outside of the timeline that we provided.
And this is David Oliver. I think another thing that we want to make sure we understand in terms of liquidity is the two primary concepts, which is making sure of continuity of service. In what ways is liquidity either not allowing that to happen or making it more difficult? And the other thing is the transferring of cost. The lack of liquidity does it put additional cost onto the bundled customers. So if we think about it in those terms as well, that would be helpful to understand how the liquidity need transfers into these requirements that we have for the POLR.
Yeah, we can do that. Thank you.
I do have one quick question for PG&E. Does your insurance pool proposal here include recovering actual procurement costs as opposed to currently now, which is a tariffed procurement?
Yes, that would be the plan. To record in a balancing account the actual costs, and then returning back to the pool all of the costs that were essentially borrowed from the other CCAs so that they would be net neutral and there wouldn't be a cost shift to the other CCAs. So it would be an actuals recovery, yes.
I believe Dan Douglas has his hand up. You can unmute yourself. There you go, Dan.
Thank you, David. PG&E's liquidity pool presentation mentioned only CCAs, although its December 17th reply comments suggested that the liquidity pool would be funded by customers of all LSEs. However, in the same December 17 comments, PG&E said, and this is a direct quote, that it does not believe that the methodology for ESPs needs to change at this time, and that referred to the methodology for the financial security requirements. DAC agrees that the FSR requirement for ESPs are well designed, they function efficiently, they've been in place for some time and need no change. But this means that it would be inequitable for DA customers to fund a liquidity pool for returning CCA customers, as this would be an inappropriate cost shift. Eric Little suggested that DA customers should contribute as well, but CalCCA's earlier slides show why this is unnecessary. His CalCCA slide 18 shows that return DA customers first have a 60-day safe harbor period to select a new ESP. If they fail to do so, they then go on the temporary bundled service rate for an additional 6 months. CalCCA slide 17 states that a 6-month period covered by the reentry fee affords the IOU time to plan for and hedge the returning customers after the 6-month ends. Well, DAC agrees and notes that for DA customers, it's actually an 8-month period, during which the return DA customers pay the utility's marginal cost of power, which means that cost shifts to other bundled customers are avoided. So we therefore request a clarification from PG&E that its liquidity proposal involves funding solely by CCA customers.
Yes. At the moment, we are only considering CCAs. We haven't considered ESPs.
Thank you, David.
Doug, did you want to add something else?
I'm confused by that logic, because a DA customer coming back, you still have the same temporality problem that you're going to have to buy energy for them, and you've got carrying costs of that until they pay you. I don't see how, and maybe this is ignorance on my part, so maybe this is quite like an informational question. How are DA customers different that you don't run the same liquidity problem that you get paid, weeks after you're putting out the money for the energy? And if the answer is you have the same problem, then I'm not sure why they wouldn't also be included. So I think I don't understand something. There's a reality there.
Yeah. I think there's a few things going on. I think one is that we're also concerned about protecting the residential nature of most CCA customers. And then one of the other things is that the ESPs generally have much more sophisticated customers and would also be exposed more directly to transitional bundled service rates, so rates that are exposed to the market. And it would allow that recovery much more quickly. And it also has to do with the size of the different providers as well.
Any additional comments? Oh, I believe Dan has one last comment.
you. Dan Douglas for the Direct Access Customer Coalition. I would add in response to the questioner that the safe harbor period, that 60-day period, is used by most DA customers to simply switch to another ESP. It's a very easy process. It's one that's been established for many years. So the actual number of customers that return to TBS is not significant. And furthermore, they're billed on a monthly basis again at the utility's marginal cost of power. So I think the concern about a cost shift simply is not significant. Thank you.
Okay, well, we're right on time here for our next subject. I want to thank the panelists on that one. That was a very nice, a very interesting discussion. Our next, oops, let me go up here. So our next panel will be roundtable discussions about risk monitoring and financial monitoring. Give me a second here. I need to. Evelyn, you already. Let me get Evelyn up here on the stage. Evelyn Call for Cal CCA will be presenting. All right, Evelyn, you're free to unmute and go ahead.
Got it. Can you hear me?
Yes, we can.
Okay, let's flip to the first slide then. Thank you. So I'm going to be talking about what kind of financial monitoring might be relevant here in the case of the Commission needing more information in advance of potential customer returns. And before I get into it, I did want to make a disclaimer. You all know I'm not a financial analyst. The ideas I'm going to be sharing today are really coming from Cal CCA's internal practices and standards committee, which is staffed by a number of the major CCA CFOs. So these ideas have been developed in that context. And I wanted to start by acknowledging the Commission's frustration. There were many of us who were taken by surprise with WCE's bankruptcy. I don't think any of us can deny that it was sudden and perhaps unexpected. So we understand the need to have greater transparency into what's going on before it happens and ends up in your lap. And I also agree with Dina. I think earlier this morning you said you're trying to stay in the realm of publicly available information, and I think we fully agree, and we're trying to work on the problem from that angle as well. So with those thoughts in mind, David, if you would flip to the next page. What we started thinking about is, are new CCAs, newly launching CCAs, the same as existing and expanding CCAs? And how do they differ? And how do what you need and what we need from them differ depending on their stage of development? And with respect to new CCAs, we talked largely about the implementation plan process and what's happening there with feasibility studies and what's being presented for implementation planning, and thought there's more rigor that could be provided there. And if you recall, WCE, I believe, launched in May 2020, and its bankruptcy occurred in June of 2021. So it was really a newly launching CCA. And so if you think what might have improved the situation there, that's kind of where we started. So as a first matter, in the first box there to the left, you see there's currently no feasibility study that is required to be submitted with an implementation plan or a pro forma financial statement. So we think more information should be provided with the initial implementation plan, and information that the governing board has been presented with. And to the next box to your right, in putting together those materials, there should be annual assumptions that are included and Commission approved assumptions. For example, you could use the market price benchmarks for RA and RPS to make sure that you're using kind of reasonable numbers when you're doing your financial statements and your feasibility study. That doesn't mean that a CCA couldn't do other scenarios, but at a minimum, they need to be doing scenarios that are using data that we kind of all accept as common. The next thing that would be important is to establish milestones for critical implementation action that needs to be taken. There are a lot of steps that go on in implementation, and making those steps more visible to the Commission and having more direct contact, and what we're suggesting is quarterly CPUC staff check-ins would again help the CPUC look in and say, you know, I understand how this is coming along. It looks good. It looks like you're progressing, so that there's more comfort in understanding where the CCA is in its development. And then finally, and most importantly, that the pro forma financial statements would be reviewed 6 months prior to launch again and updated with new financial information and presented both to the PUC and to the CCA's governing board as a check-in to say, look, we've thought about it again, we're getting ready to launch, and here's what the financials look like. So from a new CCA standpoint, we think strengthening the implementation planning process would be a good start. Next slide. For existing CCAs, and that includes expanding CCAs, there are different issues that need to be considered. It's a more complex analysis once they're up and running. So there are 4 major areas that we think are important in trying to look at the financial condition of an existing CCA. Liquidity. Obviously, we've been talking about that with PG&E. Their risk management policies, how are they handling their energy risk? What's their debt situation? And is the board and community willing to raise rates to meet the costs that they're experiencing in their procurement? So if you look at the totality of the package, you can get a sense of how the CCA is doing financially. You can't pick one out and say this is a determining factor, and this will tell us exactly whether or not they're doing well or whether we might see a potential customer return coming. So it's complicated, and we can't boil it down too simply, or we'll be missing the whole picture. Next slide. And I'm sorry if this is too small, but we attempted to put here a table, and it's from a Moody's Investor Service publication with credit rating factors for POUs. It's from 2019, and it is for POUs that are generation owning. So it's not quite the same as CCAs, and you'll see there are some differences, but it's as close as we can get in finding published ratings factors for publicly owned utilities. So the first issue they look at is what's the cost recovery framework within the service territory. And one of the things they're looking at is how quickly is the recovery of costs. And so, for example, they might look at how far off your rates are as compared with your outgoing costs. Are they matching on a year-to-year basis? Are they matching every 2 years? You know, how close are you on cost recovery? And hand in glove with that is the next factor, which is their willingness to recover costs with sound financial metrics. So as we're looking at our cost recovery framework, again, is the community willing to raise its rates to cover its cost? And it may not be year for year. There may be, like the utilities, some need for balancing through reserves. But overall, are they meeting their costs with their rates? The next is generation and power procurement risk exposure. That's what I had on the prior page as risk management. Obviously, a key factor in how you're managing your portfolio. Competitiveness, what Moody's looks at there is how do the rates for that utility compare within its region? Is it competitive? And then financial strength and liquidity, they have 3 factors they look at, which are the adjusted days liquidity on hand and 2 debt ratios, the adjusted debt ratio and the adjusted debt service coverage ratio. So those are the primary factors that a ratings agency, at least Moody's, would look at if they were looking at a POU. So what you can see is the factors that they look at are very similar to the factors I had on the prior page as indicators of CCA financial health. Next page. So how can the Commission get a line of sight into financial health and in particular, these factors through publicly available documents. CalCCA has been focused on that since WCE's bankruptcy. We started the initiative then, and we've been working to try to get standardized ways to present information to the public in order for you to be able to find things, because we know that it's very difficult to go through each CCA's website and all their meeting materials to try to locate financial statements, to try to locate discussions on rates and those kinds of things. So what we've been trying to do is to encourage the CCAs to centralize the data that you might need and make it available. And one of the things we are doing is aggregating access to what's called the key document page for all of the member CCAs. And ultimately, when everyone is up and running, what we hope to have available are the data points you would need to calculate days liquidity on hand, the data points to calculate debt ratios, their risk management policies, so you can see how they go about managing their risk, whether they have a risk oversight board or a committee, how they're structured to manage it and how they think about it, and then rate making policies and changes too. So all of those data points are available to understand where the CCA is and how it's operating. And I think we've got, I want to say 10 on the website now. It's not complete, but we hope to complete it during this quarter at some point. Next page. So with all that background and trying to come up with something that could give the commission more comfort that it might see things coming if the situation is deteriorating. So with investment grade credit rated CCAs, we're suggesting that no financial monitoring is required. As you know, we have 7 investment grade rated CCAs today. Actually, 2 of them received their first ratings after the WCE failure. So, you know, I think the ratings agencies are aware of the WCE failure, yet have found enough in the financial situations of the CCAs to give them new credit ratings. So I think you can assume that a credit rating agency is doing some level of financial monitoring to maintain those ratings. If there is no investment grade credit rating, then one of the things you might want to look at is the day's liquidity on hand. And as I said, there are data available for you to be able to calculate that. But you know, you might look at it and say, wow, there's 180 days or there's 90 days, whatever the number may be, and it'll give you a sense of where their cash position is, you know, at various points in the year. And then finally, if their day's liquidity on hand gets to a particular point, and I think we'd have to discuss what threshold is that, a consultation with the Energy Division staff would be required. So, you know, if you're seeing something happening within the CCA in terms of declining liquidity, you know, depending on the year, Energy Division may want to have a discussion and possibly, you know, take additional information to understand where the CCA is and its financial condition. So I think that is where we'd like to start the discussion, is this kind of progression. Again, it relies on publicly available information, which to us is a really important factor, and one, Dina, that you laid out at the outset.
Thank you. We'll now hear from Isidro Zambrano. I hope I'm pronouncing that correctly, Isidro?
Yes, you are. Thank you. We're also took a look at the financial monitoring for community choice aggregators. And we're of a similar opinion with our colleagues from CalCCA. I think we just have a couple of extra probably points to add. So we were looking at this as should CCAs and ESPs be required to meet critical safeguards during the implementation phase before serving customers? That's probably a conversation that needs to continue, and overall it probably looks like they should. Now here, we think that at a minimum, the commission should update the registration process to require additional ongoing information from LSCs to enable the commission to monitor financial health for consumer protection purposes. We think the commission already has the requisite jurisdiction to require the additional financial reporting pursuant to the 3 code sections below. Starting with the first one, the CPUC has consumer protection jurisdiction over CCAs and ESPs, including ensuring financial viability. PU section 366.2 states the community choice aggregators shall register with the commission, which may require additional information to ensure compliance with basic consumer protection rules and other procedural matters. PU section 394B, in determining the financial viability of the electric service provider, the commission shall take into account the number of customers the potential registrant expects to serve, the number of kilowatt hours of electricity it expects to provide, and any other appropriate criteria to ensure that residential and small commercial customers have adequate recourse in the event of fraud or non-performance. So if the commission is able to add, if they have the ability to require the additional financial information, then the monitoring, this would add a lot of transparency into the operations of the CCA, allowing for the financial monitoring of the LLCs. Next section. So the proposed approach to LLC financial monitoring we have here, the commission should implement regular monitoring of LLC financial health so that it can detect early warning signs of a potential LLC failure. We think probably if they had something like this in place, they could have seen the WCE failure probably a few months before we waited for it to play itself out that way. Maybe they can influence the LSC to begin making proper plans for exit and transition of their customers. But here, what we consider proposing, we think the commission should consider prioritizing a rollout of LSC financial reporting requirements or determine what requirements are appropriate based on a criteria similar to the buckets that we have below. We put them as priority 1 through 4. So priority 1 would be recently formed or forming CCAs. And in our opinion, those are the CCAs with the highest risk of failure. Simply because they don't, they haven't executed their plan. They don't have any kind of cash reserves to backstop, to mitigate price, energy cost volatility, and so on and so forth. So they're at the highest risk of failure early on when they've started. Priority 2, CCAs with some history of operation. Those have already started. They've had maybe a year or two under their belt, so they've proven that they can complete the operating cycle. Priority 3, CCAs with extended track record of performance. These are what we would call the more established CCAs who have hit some of their targets as far as their cash reserves or set up their rate stabilization fund, et cetera. And priority 4, the ESP serving residential and or small commercial customers. Now, with the priority 1 through 4, on the side here, we have sort of what could be required within each of these buckets. Priority 1 being the riskiest of the CCAs. We would say, based on this pyramid, we we would require, or we would ask we would propose to the commission that they require the most robust financial reporting requirements for them, which means the quarterly financial statement and annual financial statements that include a lot of additional information, like reporting on major events, maybe an update program the program implementation plans with actual data, rates and revenue analysis, hedging reporting, and on top of that, we would add the methodology and inputs. The next step here, I think we're in agreement with our Cal CCA folks. LSEs with an investment grade credit rating may not have additional requirements other than the financial statements available on a timely basis. And we concur that the professional rating agencies, they're pretty thorough in their analysis, and they have additional information, a more thorough picture of the CCAs than what is generally put out by the financial statements. So for LSEs without an investment grade credit rating, may have additional reporting requirements that include metrics, key metrics with the financial statements. Now, a lot of these can already be calculated from the financial statements that are put out, but not all of them. And if this is for the CPUC, we're thinking maybe the CCA can make it easier for them and give them a summary or a summary where they make these calculations for them, right? Now, so some of these suggested key metrics, as we would say, profitability, total liquidity resources available, current rates comparison as compared to the IOU rates, long-term energy supply procurement as compared to the load requirements, and rate of uncollectibles. We think with if we could get a clear picture on these 5 metrics, you would have a pretty clear picture of the direction of where the CCA is headed.
Thank you. And now do we want to open it up to questions?
Dina, this is David. I have a quick question just for Cal CCA. As you try to collect data, what is the specific differences between city enterprise versus JPA in regards to the kind of data that?
I will ask someone who is on, if there are any CCAs on that are municipal rather than JPAs. Could you speak up? I'm really not an expert on that, David, but what I can say is in aggregating the information that we've been going after, everyone presents it similarly. I haven't noticed any difference in those particular documents.
I've looked at quite a few of the CCAs from unis and JPAs, and some of these, I don't know that they have necessary requirements as far as what they're supposed to. They have to report something, but sometimes it's up to them to the level of detail as what they so, you know, if the CPUC could provide a framework for them to be more clear, right? And maybe a level of detail that would help them and make it more standardized.
So maybe could we back up to Edison's last slide and allow Cal CCA to respond, since this is the first time we've seen the slide and the proposal? And obviously, we don't have a complete response today since we haven't had time to process it. I do see some areas where we're aligned. Investment grade credit rating, obviously, we're aligned. Making financial statements available, we're trying to do that right now in the website. I don't think we have any objections to providing rates of uncollectibles. That was one thing we talked about, and debt and those kinds of things. So I think there's a lot of commonality here. Where we probably start coming apart is, it was the point that Dina made earlier, which is how deeply are you suggesting we get into rates and revenues analysis? And hedging reporting is actually into that confidential area. And if you're not willing to ask ESPs for their hedge data, you know, which is confidential, why are you asking CCAs for their hedge data? So I would say those top 2 points on his triangle here are things that are difficult, and I think that start to cross the line depending on how you're doing them. So I guess I would ask Edison, how are you thinking about those top 2 boxes? What's in the rates and revenue analysis, and what does the hedging reporting look like that you're suggesting?
Well, when it comes to rates, I was thinking more about how the rates are that they're charging compared to their local IOU, right? Most of the CCAs, and just in comparison, because I think usually they post that on their website, but you have to go through quite a bit of work to sort of find what the difference is. Sometimes they'll note it in their financial statements with well, they used to. I don't think they do anymore. Or on their website, they'll note it that, you know, we're 2% lower than your local IOU or something like that. Which is good information. That's one of the things I mean by that. And that it's just that if you're already at, for the CCUs, if they're already at the same price as the IOUs, they might have a hard time trying to increase rates in times of need, right?
Yeah, and on that point, I think the PUC is now working on a rate comparison website, so that information should be available anyway in some form by the time that website gets finished. And as to your point on rate comparisons, if they're at parity, you know, is there going to be pressure on raising rates further? And I think you've seen with a couple of the CCAs, depending on the portfolios they're building, their rates may be above the IOU's rate if it's 100% clean or something like that. So I don't think you can say simply because someone's rates are or are not at parity or below that's an indicator of willingness to raise rates. I think you need to look more deeply into what they've actually done and how frequently they've raised rates. So in terms of the revenue analysis, then what were you thinking?
The revenue analysis, well, I mean, that one is just, it's part of the rates and revenue analysis. So you can see, well, in terms of like what, if they hike up, right, if they want to do an increase, a rate increase because they need it, what does it translate to on, let's say, a monthly basis? I know I found some of these analyses in their board minutes. I know WC did that when they were still trying to get out of their circumstances. So, you know, if we're there, they talk about raising rates a couple of cents and how that translates over in terms of revenues for the month. Now, when I see that, I knew how far behind they were in terms of them and their insolvency, right? So if they raised it a couple of pennies, they were making an extra couple $100,000, but they were insolvent by $5 million for the year. Then I know that kind of a rate increase, it's only going to prolong their situation, but it isn't going to solve it for them, right?
And I want to make a quick clarification, Abby, because you've mentioned me saying that it would only be public information. I didn't actually state that as a declarative. I was asked, that was a question, not a statement.
Okay, yeah, I thought it was a point of distinction you made between CCAs and ESPs. But thank you for the clarification.
Oh, I'm sorry, who's that? Who?
I was just going to say, I think we have to be really careful about starting to push our way into the governing board's job. And as I said, the farther we go up this list, the more we get toward that very careful line. And so I think there's a lot more discussion that needs to be had around the financial monitoring, and I'll look forward to that.
As far as the hedging methodologies, we're not looking for market secrets or market intelligence. There, I think I was looking more for commentary on from the CCAs in their reporting on whether or what's their load rate, right? 0.5 down there. Long-term supply, energy procurement versus their load requirement. So if they have 200 million in energy costs annually, how much of that is procured ahead of time, right? Which will help you get a sense of their exposure to market price volatility.
So
it only needs to be a comment, right? A lot of them will tell you 90% of our forward load we've already contracted for, something like that.
So you're counting only physical hedges. You're not counting financial hedges in that.
Well, I mean, it depends how they do it. They could state both if they want. The more thorough the information, the better.
Well, okay. I would just say that certainly the discussion of public information versus maybe market sensitive information and how that may or may not be used here, if at all, is certainly something that would be further discussed as we got into details of any kind of financial monitoring. I wanted to let Franco Gadiri speak. He's with the Energy Division. Franco?
Hi, thank you. Both great presentations. I just had a question for Evelyn's slide 56. I agree with all the criteria, which were the 4 main areas to focus on for evaluating existing CCA's financial performance. However, I am curious, and I would like you to go into more detail. How would you quantitatively, rate or scale a willingness to adjust rates? And a caveat that I want to bring up to everyone is for single city CCAs, to raise their rates, they have to go through the city council. The city council members are not necessarily involved in energy matters every single day, like a board of governors would be for JPA CCAs. So not only is there that aspect, but there's a lot high turnover of who's the city council member. So one set of city council members might not want to adjust rates. They want to keep rates as low as possible, and that's the firm stance by them. But then in the next city council member group session, they'll be more receptive. So if you could just go into more detail about that, that'd be great.
You are
sorry. Yeah, Franco, I think of it as really, have they adjusted rates in the past to meet their cost recovery needs, right? I think you can look back at meetings where boards have voted to increase rates or boards have rejected rate increases. I think with WCE, they rejected a rate increase. So it is more subjective than it is necessarily having a metric you can go into. But that's how I would look at it.
Okay, great. Thank you. We've got another hand up, Kyle Nevis.
Hi, thanks. Could everyone hear me?
Yeah, and can you tell us who you're with?
Yes, I'm with the Public Advocate's Office. Thanks for these presentations. They're both helpful and got a lot of good ideas. I have a couple questions for CalCCA and a couple questions for the panel. So first, just for CalCCA, Thanks for that landing page with all those links. It is a good start. I would say that having tried to track down a lot of these documents, it would be slightly more helpful if they were systematically listing links to documents for the CCAs, like the most recent quarterly financial statement. And then beyond that, just a couple questions. One is, why would the greater rigor requirements not apply to expansions of existing CCAs? And then the other question is just, what would the threshold be for graduation from a new to existing CCA status? Would that be size, financial health, age, or some combination of factors?
Evie, you're on mute again.
Yeah, as for the first question, and I'll probably forget the three of them as I go here, but if you look at the page, what we are trying to do is to say key documents. We have the same format, which is the first thing I think is financial documents. And within that, we'll have annual, audited, and quarterly. Some of them are doing monthly because they don't do quarterlies. I think if you look at Sonoma's, for example, they've got monthlies up. But it should be accessible very easily from that standpoint. Is that what you were asking? Or was it something different?
I mean, as I'm looking at the page, I just see that these are taking me to the landing pages of the CCAs themselves, which are clear to varying degrees.
There are some links that are not live in there, so I don't know which ones you're looking at, but it should take you to a landing page that has the same document list on it that we have, which is the key documents rubric.
Right.
But we can talk about that some other time if you'd like, but I can help you walk through it.
Yeah, that's fair. Relatively minor, though.
Okay, you had a question about when do you graduate from new to existing? And I do think that's a good question. Obviously, it's something that Edison has thought about, and certainly we can talk about that more. And with expanding CCAs, I guess to that point, they're existing CCAs. They've been out there for a while. Presumably, they know what they're doing. They're still operating. They've done some forecasting. So I think they're not the same beast as a newly launching CCA who has no experience. So I think they belong more in the existing CCA bucket than necessarily the newly launching.
Okay, thanks. Then just a couple other questions for the panel then. And this is where, thinking just a hypothetical scenario, say we did have a case where, you have financial reporting requirements and you start to see some of these early warning signs going off on a particular CCA. Just two questions then. What would the POLR actually do in that case if there are signs of something that's going to happen soon? And then in the scenario where the CCA successfully emerges from that period of instability, how would the POLR recover the opportunity cost of financial actions it might have taken that might not end up having been needed?
I don't think that we're proposing that the POLR does anything with that information. I think the point is the commission and the POLR can prepare themselves if they think something's coming. But if you want to trigger additional costs when you think someone is in financial trouble before they're actually moved into that zone, it's going to become self-fulfilling, right? You're going to add costs to their operations by making them procure a backstop through the POLR, and suddenly it's even more difficult to stay healthy. So I don't think we're proposing that you take action at that point. But as I understood the commission's complaint, it was that there was no notice that it was coming, and everyone was scrambling to try to figure out how to handle it. And what we're hoping to do here is to get the FSR properly formulated and get the deregistration rules confirmed and make it simpler for it to happen if it happens.
And some related questions to that. I'm wondering how often can a credit rating change, and how does the commission find out about updates to a CCA's credit rating?
Dina, that's something that will be on their key documents landing page, and they're obligated to update it. But I don't think there would be any difficulty if you wanted them to report changes in their credit ratings. I think they'd be happy to do that.
Evelyn, you mentioned some requirements for during the implementation phase of a CCA prior to them beginning service on some economic guidelines. Would the CPUC be able to force a CCA to delay if they don't meet certain financial guidelines in the implementation phase? Or are you just suggesting that they need to report those things, and as long as they're reported on a timely basis and correctly, then they're fine, whether it says they're in good shape or not?
Yeah, I mean, I think you can, if what you're trying to do is anticipate challenges, you'll see them coming. I also think if you look at the last lower right box, what we suggested was that 6-month pre-launch update needs to go not only to the PUC, but to their governing board. So it's just more discipline, David, I think, to the process, the financial planning process. And some CCAs are already doing that before they launch, but I don't think it's universal.
So one of the things you recommended is a feasibility report that need to be filed. I'm not sure what we would be able to do with a feasibility report. I mean,
well, you know, I think you look at assumptions, right? What are the assumptions that underlie the calculations that demonstrate that it's a viable entity? You know,
I understand that. I'm just curious as to what you think we could do if we thought it wasn't a viable entity.
Again, as I understand your need, it's to be able to see things coming, to have a line of sight into how they're doing. I mean, there's a clear boundary here jurisdictionally that we're all trying to dance around, which is, you know, it's the governing boards who make financial decisions, make rate decisions, and determine how to handle those things. And so we're trying to respect that, at the same time respecting your need to know if you need to begin preparing for something.
Thank you. Scott Olson from NRG, your microphone is open.
Thanks, David. Can you hear me okay?
Yes.
Great, thanks. I just want to make one distinction about ESPs and CCAs. ESPs generally are multinational corporations with revenues across multiple states, multiple countries often. So certainly we have revenues from many different sources that are not just California. Many of us are publicly traded companies with public information on all that we are doing financially, so that's very easy to find. But certainly the impacts of our specific positions in California or the West will be much more muted relative to a CCA, since again, we have quite a bit of operations in other locations. Just wanted to make that point. Thanks.
Doug Carpa.
Yeah, Doug Carpa, Peninsula Clean Energy. You know, kind of on that point, you know, and I certainly understand the Commission's need for financial data, and I'm sure we're going to work something out there. But to that point, actually, that you were just raising about a lot of ESPs being units of much larger entities, raises a bit of an issue, because it's hard to assess. Like for CCA, we can take a look at the ability of the entity as a whole to survive, and you know, for CCA, like not operating in California is a existential event. But for somebody like, say, EDF, which is like what, the 5th largest energy company in the world, ceasing operation in California is a pretty minor event. And so we're obviously not interested in like whether EDF or, and I just picked them because they're huge, or some other, you know, national organization goes bankrupt. We're really interested in what is the probability that they're about to cease operations in California, which is kind of like the operations of a single unit, a small one at that, of a much larger entity. I don't have a good answer. I'm wondering if the ESP folks might know how to give the Commission insight into, I don't know, like how that unit is doing financially, or like whether they're still turning a profit in California and that sort of thing. Because I know there's a lot of concerns about ESPs kind of drying up and blowing away. And I have no answers. I'm just curious what thinking around that is.
Yeah, this is Scott. ESPs drying up and blowing away. I have no idea where you're getting that from, Doug. That the ESPs that are in this business, the big ones, are the ones that have been here for the last 15 years. The NRGs, Constellations, Calpine, Shells, we're here, we're in it for the long run. I'm going to turn your question around, actually, in that the impact of our California business, you're right, is fairly small for many of the ESPs on our books. So if we decide to leave, that would be a very orderly transition. There's no concern about, oh boy, all of a sudden, like you said, all of EDF goes bankrupt. That issue, again, is much more of a CCA concern because your exposure is fully in California, where the exposure of the business of any of the ESPs in California, I think, is quite small. It'd be an orderly transition. And as we've talked about within this entire proceeding, the rules are very well established for how to handle that and to be sure there's no cost shift.
Yeah, no, that good points. Thank you so much. Yeah, no, that's a very solid point. It sounds like the sort of thing that, like, as long as, you know, if there are rules around it being orderly and there's, like, I don't know, 3 months advance notice, that sort of thing, that's, yeah, I can see why that is easily handled. Oh, thank you. I appreciate the answer.
It's also, and just maybe to help Doug and others, direct access customers contract directly with the DACC. They're opt-in. So it would be a breach of contract between the ESP and its customer if there was some sort of situation where the ESP tried to just send them involuntarily back to the IOUs. That's a slight difference there as well. Whether or not it's relevant is for further. One, we did have, I want our questions here, and I wanted to see if there's anybody, I believe it was from UCAN or somebody, but they actually talked about reporting by the CCAs based on specific triggers. And I also saw that possibly CalCCA also mentioned that in case there were days of liquidity on hand fell below a certain level. Would that be self-reported, or would that be something that they have to constantly be updating?
That would be something that would be self-reported. Alternatively, you will, if you get quarterly data, you can probably do your own calculation.
Also, we have a question here from on the chat from Cal Advocates for Energy Division. It says discussion of CCA hedging is coterminous or maybe even overlapping with issues in the RA proceeding. Can you please clarify which CCA hedging issues will be addressed in this proceeding versus in the RA proceeding? So I would, Dina can back me up on this, but we would not be doing any kind of, making any kind of rule making in terms of RA requirements. We would not be telling people they need to acquire RA. We would not be telling, in this proceeding, we would just be, in this case, it would just be for informational purposes, which I realize also the RA proceeding also gets information. So that would be a detail to be worked out. But in no sense would this be we are not at this point proposing the POLR process be able to dictate RA concerns. That would be something that the RA proceeding would undertake.
I agree with that.
Do we have any final comments on this risk monitoring and financial monitoring Q&A? If not, we can probably wrap up a couple of minutes early. I will, I think I will finish off here by noting that we will be accepting written comments on this and other issues as you see fit. We on March 28th. And then there will be a chance for reply comments afterwards. The ruling had several questions that we hope to direct parties to that we were seeking to form on the record. This presentation and this recording will be posted on the CalCCA website. I will send that out as a link to the service list as soon as it is available. And if there are no other questions or comments at this time, I think I will turn it over to Commissioner Houck again, who has some final comments that she wishes to make at this time. Commissioner Houck, are you available?
Yeah, thank you, David. I just wanted to thank everyone for their participation today. This was a really good discussion. It gives us a lot to think about. I know we're looking forward to getting the written comments and moving this phase of the proceeding further. So I appreciate everyone's time and thought into how to move some of these complex issues forward. And again, look forward to the comments and talking with the different parties as we move this forward. So thank you. And thank you, staff, especially to David and Dina for all of their work, Judge Heck and Aaron Seibert in my office for all of their work in putting this workshop together.
Thank you, Commissioner. And again, yes, thank you to all the parties. Dina, did you have anything else you wanted to add?
No, thank you very much, everybody. Thank you for participating and giving us your thoughts.
Okay, well, enjoy the rest of the week, everybody. We look forward to your comments.